All right, good morning, everyone. I'm going to call to order the Code Enforcement Magistrate hearing for February 21st, 2024. Folks, need quiet so that we can continue with the hearing. Thank you very much. So this is the Code Enforcement Magistrate hearing from Martin County for February 21st, 2024 at 9 a.m. If you'll please rise, join me in the Pledge of Allegiance.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right, please be seated. I'm going to try and call these cases in the order of folks that arrived here and have business before the hearing. So the first case is going to be, actually it's down about number 4 on the docket. It's case number ENF 2023-110163. The respondent is Capital C, Inc., and it's a violation case, and Officer Counselor is going to testify. You are too as well, sir? Yes, sir. All right. All right, if you'll both raise your right hands. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
I do.
All right.
I'm sorry, I only got one more witness. It was a little.
All right. And Ms. Bradley, and sir, who are you?
I am the owner of Capital C.
Of Capital C, okay.
Name's Corey Crowley.
All right, if you'll just both raise your right hands, thank you. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I swear.
All right, and you said Ford? Mr. Ford?
Mr. Crowley.
Crowley.
Crowley. C-R-O-W-L-E-Y.
C-R-O-W-L-E-Y. Okay. Mr. Crowley, this is a violation hearing. We're going to hear from the county first. They're going to present their evidence, assuming that they make what the law calls a prima facie case, meaning if everything they say is accurate and correct. I can find you then responsible for the violation. The burden then flips to you, and then you'll be able to present evidence. You'll be able to question the officers if need be, and we'll just continue and see where we are at the conclusion. You can remain there and look at the monitor in front of you, or you can sit down and listen to their case.
I'm fine.
Okay. All right. Very good. All right. So we're going to hear from the county. Officer Counselor, you're going to testify?
Yes. My name is Chris Counselor. I've been sworn in. I'm a code compliance investigator for Martin County. The respondent, Capital C, Inc., and a representative is present. The case concerns the property at 4878 Southeast Commerce Avenue, located within Stuart, Florida, located within Martin County. This case was not generated from an anonymous complaint. According to the official records of the property appraiser of the Martin County, the property owner is Capital C, Inc., which is County Exhibit 1. On January 2nd, 2024, I responded to a complaint of camping on a vacant lot. I inspected the property. At the time, I observed camping and multiple recreation vehicles parked on the property, which is an undeveloped vacant lot. At the time I photographed the property, the photographs accurately show what I saw then, and it's marked as County Exhibits 2, 3, 4, 5, 6, and 7, with a screenshot of internet ads that were sent with the complaint as Exhibits 8 and 9. 2. Three. 4. 5. This is just showing out-of-state tags. 6.
And I'm sorry, how many RVs? 3? Total?
At the time, there's 3, possibly 4. Yeah, 4.
All right.
6. County Exhibit 7. Exhibit 8 was one of the, this is one of the ads that was sent with the complaint. And Exhibit 9, another ad showing Based upon the investigation, I issued a notice of violation to Capital C Inc. on January 3rd, 2024, marked as County Exhibit 10. In the notice, I cited the following Martin County Code violations: Section 3.11, permitted uses, and Section 3.201.c.2.h for accessory uses for the use of RVs for overnight staying or living purposes. In the notice of violation, the respondent was given until January 8, 2023 to correct the violation and was informed of the need to contact Martin County Code Enforcement upon doing so. Due to the nature of the violation, a notice of hearing was also issued by certified mail on January 3rd, 2024, and is marked as County Exhibit 11. Exhibit 10 is my initial NOV signature. Exhibit 11, there's a hearing. Codes at the time, my signature. On January 12, 2024, Code Enforcement had a meeting with county legal staff, the CRA representatives, and growth management to review the details of this case and what codes were appropriate based on the location and nature of the violations. Based on upon the meeting, an amended notice of violation was sent. Also, an amended notice of violation and notice of hearing were sent to Capital C Inc. on January 25th, 2024, marked as County Exhibits 12. This is the amended NOV, where we updated the codes to include Section 10.1.c.1, Development Order Required, Section 12.603.2.b, Permitted Uses within the Port Salerno Redevelopment Zoning District, and Section 12.1.047H, Development Standards for the RV usage as living spaces on the property. In the notice of violation, the respondent was given until February 16, 2024 to correct the violation and was informed they need to contact Martin County Code Enforcement upon doing so. The amended NOV, the updated codes, my signature. Exhibit 13 is the amended notice of hearing, updated codes, and my signature for today's hearing of February 21st. The return receipt was not received, so on February 9th, 2024, I posted the property. A photo of the posting and the affidavit of posting are marked as County Exhibits 14 and 15. 14 is my posting. Exhibit 15 is my affidavit of posting. There has been email correspondence with the owner where the violations were discussed and what needed to be done to correct the violations. I and county staff have inspected the property multiple times in February to show that some RVs have camped at the property for numerous nights. Those photos are marked as County Exhibits 16 through 27. This goes back to February 9th. I want you to pay attention to this RV right here on the corner. This is the one, basically, it's been there multiple nights, so in case it's argued that it's just for overnight staying. Exhibit 7, February 9th. Again, February 9th. That's Exhibit 18. Exhibit 19. This is the RV in question that's been there multiple nights. This is on February 16th. Still there. February 20. Exhibit 22 is February 16th. Exhibit 23 is February 19th. Exhibit 25, there's the RV in question that was there since the 9th. Exhibit 26. Exhibit 27 on the 19th. And, okay. With no compliance on the property, I went to the property again on February 20th, 2020, and saw that the property was still in violation as it was being used as a campground. At the time I photographed the property, the photographs accurately show what I saw then and marked as my final exhibits 28, 29, 30, 31, 32, and 33. So starting with Exhibit 29, these are all taken as of yesterday. RV in question from the 9th is still there on the corner. Long view of the property. 32 and 33. Requested all counties exhibits be received in evidence based upon testimony.
Your Honor, if I might, at this point, there's a couple of the witnesses we want to hear from before we wrap up the case.
Okay. I'm assuming that you're still asking that the exhibits be entered into evidence?
Yes.
All right. So, okay. First, do you have any objection to any of the exhibits that have been?
I haven't seen any of exhibits ever.
Oh, they were not on your screen?
No, I mean, that's the first time I'm seeing them, but I've never been shown any evidence. All I was sent was the notifications. Typically, when I get a code violation, I get pages of photos and so forth of the evidence that I'm able to then correct.
Okay, but you had an opportunity to.
Here now, but I've never been able to see the evidence to be able to correct
That
it.
is the
I
evidence.
know, but I'm saying, until this meeting, I have never seen these photos.
Me either.
Right, but I can't correct something I don't understand.
Well,
If my grass was overgrown and you showed me grass pictures, then I would understand that, and
you
that
know,
would.
don't argue with me. That's not going to work. Let me just tell you that what you've been shown shows the
Yes.
alleged violation.
Except there's two cases, not one, and I'm not quite certain which one we're talking about.
Talking about the one that involves the particular piece of property that you've been shown.
Two identical pieces of property side by side. So which are these photos for? I'm not certain.
Can I clarify, Your Honor?
Yes.
This case considers one contiguous piece of land. However, it's divided in half for tax purposes. It has two PCN numbers. The
Okay.
violations, the evidence, all are common to both pieces of property, with one exception, one exhibit that'll be on the southernmost piece. But these exhibits that we just saw apply to both pieces, but because of the way the ordinance is written, because there's two tax lots involved, we have to bring two separate cases.
Well, I propose that the second lot, the case number was 0159, there is no parking on that lot. All the parking is on the northern end. So I would like this case removed. Or provide evidence that there's parking on that lot.
Well,
Well, we haven't heard that case yet. Let's,
Well, I mean, my point is they're saying both cases at the same time, which I can't understand because I'm being accused of development orders, and they have to provide proof of development, which happens on a specific property.
we
I have
aren't,
two separate properties.
we
here.
aren't there yet.
Okay.
We just aren't there yet.
Your Honor, if you look at back to County Exhibit 9, based off that diagram, basically what we're talking about for this first case would be exhibits, see the lots where it says 13, 14, 15, and 16? Where
Yeah.
it does say parking anywhere here, with the arrows indicated within the ad? That's the case we're talking about right now, is that lot that goes to section 13, 14, 15, and 16 is what this,
And then what is the next case that I
Case-
haven't heard yet?
the next case will be for the lots 9, 10, 11, and 12.
Well, 90% of the photos in this, that he just presented are not on this case. So we have a problem in terms of evidence. I dispute the fact that all of the photos he said are for the case we're talking about. It's not the same piece of property.
Okay, hang on. Let's go back.
Okay.
We can go by one, and I can show you. That picture there has one RV on one piece of property and one RV
I
on
don't know what that picture there
one
is.
that's on the screen.
Okay, that's number 24,
That's Exhibit 2. I'm going back to Exhibit 2.
Exhibit 2.
So we need to look at these photos in terms, if we're talking, I believe we can only talk about one case at a time, and I've never, is that fair?
We were talking about the first case.
Which is number 59?
It's
63.
163.
Okay, great. We'll talk about that case. So let's look at the evidence with regards to 163 and remove almost all of these photos. They do not apply.
Okay, can you identify looking at I'm looking at Exhibit 3, it pops up as Exhibit 3. Well, maybe my numbers are different than your numbers.
You can look at that photo. That is not the property that we're discussing today. Neither is the lot that he mentioned. The RV that he singled out for complaining that it was there for multiple nights is certainly not on that lot. It's on the corner of the other lot. The way they're arguing this case makes it impossible for me to comply. I don't even understand what I'm doing because the evidence is muddled.
Yeah. It's not exactly how I'm viewing it, but let me just tell you that we do need to be clear as to which vehicles are parked on which parcel for identification purposes.
Okay.
So I'm looking at what you've got marked as Exhibit 2. Hang on just a second. Do you know which parcel that is?
I'm going to pull up the property appraiser for you, Mr. McMinn, or Mr.
No, the answer is no. She has to pull up the property appraiser. I can tell you if you'd like the answer.
No, I'm not ready to hear from you, and as a matter of fact, we're still working with the county's case. I hear your objection, but I'm not even ready to rule on it at this point, so.
Okay, so this will show you a better understanding of the lots that are tied to this first case.
You can use the church as a reference in the photos. You can see the lot goes to the edge of the church, and that just gives you a general reference of where we are when you look at the photos. Just lot number 5 behind the church. So maybe 2 or 3 photos in that whole set of photos that's evidence with regards to the case they're talking about.
All right, and I'm addressing the county now. What,
I'll go through each photo. Basically, Exhibit 2,
yeah. Is that the church in the background?
so basically, based off his stating the church as the dividing line, all 3 of those RVs
Well,
pertain.
2 on the left are, but yeah.
Exhibit 3, this would apply to the next case.
Not this, what he's saying is not this case,
This is just a far view, basically. So,
not this case.
right, but it still shows the 3 down at the far end of the property.
On the other case. Who knows? Who knows? Who knows? I mean, just one piece of evidence that doesn't relate shouldn't be enough to say we have to go back to the drawing board and get this thing straight.
No, that's really not true. I may throw out some of these exhibits just because they
I need them
don't
for the-
line up with
the
their
appeal.
case, but that's not actually true. If in fact one piece of evidence shows that you're in violation of the code, then I can find you in violation.
Yeah, but I have 3 separate violations. Typically, there's just 1 violation. I have 3. So we need to go back. I think the right proper course of action is to send us back and have us negotiate something.
No,
I'm
sir.
interested in applying I just can't.
The proper course is for me to hear the evidence and then hear you.
Okay, that's my
Okay, and you're trying to jump in where you don't belong at the moment. All right, so,
We're at Exhibit 16.
yes,
Basically, in the front of the picture, I would say these 4 RVs are probably located in the northern property, but the exhibits to the far distance would be applied to this case. 17, this would apply to the other property. Other property. 19, this one clearly is on the property in question for this case. Exhibit 20, it's just the same day picture, but that one in the background. Exhibit 21, again, the one in the background, same date. So, Exhibit 22, Exhibit 23. This one would be on the border between the 2 properties, basically using the church as the reference. Exhibit 24, church's reference, I would say at least this one would be on the line, but then you have this one and this one would both apply to this case. This was taken the 19th. Then we'll jump, I'll go to the 20th. We have a line of RVs. 29, these would apply to the next case, to the northern property. These ones here on the front would apply to this case.
Those are actually on the other property, but
One. Using the church as a reference, I would say that one applies to this case. 32. And then Exhibit 33. These would probably apply to the next case.
All right, so tell me, we may have to go just photo by photo, but tell me which of these exhibits do not apply to this case. So 33,
Your Honor, I made a list if you wish. We would stipulate to the exclusion of 3, 4, 5, 6, 7, 16, 17, 18, 29, and 33.
let's go one by one. Let's start at number 3.
Three.
Okay, do we agree that that's not on this particular property,
Yes.
number 3? Okay, next,
4.
which one?
4, we would exclude.
4,
Well, 4 shows the ones at the far end of the property, down here.
Oh, okay. I stand corrected. That one pertains to both properties. It pertains to the case in question.
okay,
Exhibit 5.
5, we would exclude.
Okay.
6,
6, we would exclude.
okay, 7,
7, we would exclude.
8,
8's the ad.
okay,
9's the ad advertising the parking.
all right. Photos down further. 16,
16. It shows the one in the background. Here.
all right,
16, the background photos are on this property.
17. There's
17 would exclude.
that pan right there by the church.
18,
I would exclude.
18 exclude.
19. From the, would be taken,
tell me about 19.
the 16th, this would apply because there's,
Okay, 20,
20 would, basically a faraway shop showing that same camper that was in Exhibit 19.
Okay.
21 still shows same camper in the distance. Exhibit 22, similar to Exhibit 21. Exhibit 23.
actually,
It's the church. This would be from the 19th. In the church's reference, I would say that one applies. 24. I would say these 3 apply based off the position to the church. 24 applies. 25 wouldn't. Exclude.
okay,
26, I would exclude from this case. 27, it's a full shot of the 2 properties together. I would say it would count because it basically shows these ones at the far end, just from a different angle. 28. On the same RVs, this is the 20th, it's my first day. 29, I would exclude. 30. I'd say these ones apply because these 2 in reference to the church. Same vehicle, different angle. There's the church. I would say it applies. 32, there's the church. There's the 2 campers. Exhibit 33, I would say this one could be excluded.
All right. Mr. Crowley, come on back up. The county has now stated that they are willing to exclude 3, 5, 6, 7, 17, 18, 25, 26, 29, and 33. Are you in agreement with that?
There's additional ones that do not show my property, and I'll use that as a basis of appeal, that the evidence is muddled, and I can't understand it. And we would come back and clean it up, and I can have a clean case, and I can.
I don't think there's a legal basis called muddle, but
This improper evidence. They are presenting evidence on something that is not my property. If one single photo has nothing on my property that you include in this case, I'll use that as a basis for appeal at the circuit court.
okay.
I recommend that we just go clean it up and come back next month. I'm willing to.
What's the county's position?
No, not at this point. We want
Okay.
an order.
So county wants to go forward, it's their case. And any other evidence you wish to exclude?
No, Your Honor.
All right. So do you have specific exhibit numbers that you want excluded more than these?
I'd like to exclude all of them, yeah, because even some of the ones that are, well, I'm not going to, listen, this is the parcel numbers, you need surveys, we need, to understand what's going on. That's all I'm saying. I'm not certain what the rush is with the county. Let's get some surveys, and we can take some pictures. I'll go out there myself, and I'll point to the cars, and I'll make certain it's all clean. I'm not trying, you can't hide parking RVs on a piece of property. But as of right now, this is only going to get messier as we go forward. I have a long list of reasons why. It just makes sense to go back to the table, which I've been trying to talk to John. My last communication with him is, we're not going to agree, let's go to the magistrate. And he wanted you guys to come here and negotiate it. But I've reached out. I'm trying to understand the code. I'm doing this because I believe I'm within my rights, which is why I plan on taking this to the circuit court.
Okay.
You'll see that more as we go forward. But as you can see already, the basis for this whole thing is
So your
messy.
understanding is that you have the right to use your property as an RV park?
No, I don't have a right to use my property as an RV park. I'm not using my property as an RV park. The definition of an RV park precludes that I charge, which I do not charge. People are parking on my lot, which I'm legally allowed to by section Article 12, Table PS5, permitted uses, says I'm able to have a parking lot.
Your Honor, I object to this. We haven't finished presenting our case in chief
Yeah,
yet.
that's really, we are getting the cart before the horse. So let's,
Any more questions for me now, or you want to?
I do. You said you objected to all the evidence?
I object to everything.
Okay.
I'm here in objection to
All
the
right,
whole
so-
case. I feel like I'm being harassed.
Okay, so over your objection, I am going to exclude items 3, 5, 6, 7, 17, 18, 25, 26, 29, and 33, but I am going to allow the remainder of the evidence
Exclude from the-
into evidence. So
So we'll add those to the next case, I guess? I mean, how are we going to do that?
it's up to the county to bring its evidence.
Right.
Okay. All right, so you have another witness?
Well, after the evidence, I want to have a couple more questions for
All
Officer
right.
Counsel. And then
So you've got everything into evidence other than the ones that I just recited?
Exactly.
Okay.
So, Officer Counsel, directing, if you could direct us to Exhibit 9. And what does that show?
This is basically showing an ad that was listed advertising the park,
And who placed that ad?
downtown Salerno Parking Authority.
I'm sorry, who?
1 Acre hosted by James C.
I accept that that's my advertisement.
Okay.
So, directing your attention to the map, where we have 13, 14, 15, and 16.
Yes, sir.
On the upper one, lots 15 and 16, what is written on the map there, on the advertisement?
It says parking anywhere here.
Now, I'm in a little small corner, upper left-hand corner.
Fire pit or Sandy Beach.
And the pictures to the right, are they pictures of that fire? The questions are for the Officer Counsel.
Yes, the pictures are showing the fire pit and the
And the fire pit
And Sandy
includes
Beach.
pilings that have been driven into the ground
Correct, sir.
and sand that has been placed on the property?
Yes, sir.
Oh, sorry, then I'll pick him. All right, let me start. The photographs to the right show pilings that have been placed into the ground,
Yes, sir.
sand that has been placed on the ground,
Correct.
and a stone fire structure that's been placed on this lot.
Also correct.
All right, no other further questions for you at that time. At this time, I'd like to call Mr. Paul Schilling.
Good morning.
Mr. Schilling, good morning. You've been sworn in.
Yes, Your Honor.
Mr. Schilling, are you employed by Martin County?
Yes,
And what is your position?
Growth Management Director?
And as the director, you're the highest ranking official in the Growth Management Department.
Yes,
And is Growth Management responsible for the issuance of development orders?
yes.
And can you tell the court what the definition of development of land is?
So a development means, and I can read the definitions as section 10.2.b.2. So development means the carrying out of any building activity, mining operation, the making of any material change in the redevelopment or modification of an existing use or appearance of a structure or land, which creates additional impacts, or the dividing of land into 3 or more parcels, so forth and so on. So in essence, any change to vacant land requires a development order. So generally, those are accomplished either by way of the development review process, which issues a development order, but depending if it's a minor or major development, which are approved by the Board of County Commissioners, and as well as building permits, which we participate in that review as well with the building department. So changes to land, whether it be clearing, filling, constructing, either vertical or horizontal, require either building permits or development orders.
The operation of a parking lot require a development order?
Yes,
And are you familiar with the piece of land that's the subject of today's hearing?
yes,
Is there any development order in place for that land?
no.
No further questions for this witness.
Okay, do you have any questions for Mr. Schilling?
Well, there is no development order for a parking lot. If there was, then thousands of vacant commercial properties across Martin County would be in violation. And if I'm found in violation, I'll go and start doing those codes. I can name, the Twisted Tuna parking lot got millings over it.
Objection, Your Honor.
There's no development order.
Any other property other than the one we're talking?
Well, I'm just saying that I challenge, and Paul and I know each other, and I'm willing to have this conversation, but there's no building permit for a parking. So I go, according to section 12, table PS5, my property is in the Port Salona redevelopment area, and I am legally allowed to have a parking lot. Is that correct?
The permitted uses do, I believe, indicate that a parking lot is a permitted use. However, a development order is not exempt from a requirement for a development order.
I say that it is because there's no building permit. I've been to the building department, and there is no specific building permit for a parking. I'm in a circle. Like, I could go there and they say they need to go get a building permit, but I can't go to the building department and get a building permit because the one doesn't exist. Parking lots are typically created as an accessory use, and so they're part of an overall development order. There is and has never been a development order issued for a parking lot in Martin County, except for in small cases where a developer wants to do like a little small sales office or something like that. That's the only time that's ever been done. Never been done. So I'm the first person that's being cited for having a parking lot without a development order.
Let me just ask one question. Mr. Schilling, if a development order were to be issued in this case, who would be the issuing authority? Would it be you or would it be the county commission?
More than likely, it would be myself as the Growth Management Director, as the designee for the county administrator.
Okay, but you've never had an application for a development order for this particular parking lot?
No, sir.
Okay.
Have you had an application for any parking lot?
There are a couple instances in which, and I can't name them, which may have been standalone parking lots, facilities that were done as part of ecosystems and trailheads. Those, in fact, also had development orders because they had other improvements, whether they be drainage, because I can get into all the particulars of all this, but the requirements of a parking lot is not just pave it and you're done.
I haven't paved it.
there are technical requirements and a process to go through in order to develop a parking lot.
I'm not developing a parking lot,
wait a
I'm
minute,
using it.
wait a minute.
Okay, I'm saying, it's like, that's the point, that's the issue here.
Let Mr. Schilling speak.
In the majority of cases, the parking lot is ancillary and accessory to the primary use, which is a medical office or a office building, or for all intents and
For
purposes.
any use,
Yes,
any primary use.
yes, sir.
So you wind up with, in this particular case, the use of a parcel, or perhaps two parcels, that, where the primary use, as intended by Mr. Crowley, appears to be a parking area for RVs.
No, a parking lot. A parking lot. I'm only allowed to have a parking lot. I'm not allowed to have an RV park. So I have a parking lot. That's been my argument from the beginning. And all of the evidence is, this is a development order. So when the attorney was talking about the sand and things like that, possibly he was asking, are those part of the development? There's no evidence in their case presented towards those things. So that was a little bit unfair on his part. What they have presented evidence for is use. And they're using the development code to say that I developed something. I haven't done anything to the lot. It's a sand lot with grass. I haven't paved it, put millings down. I've done nothing to the lot. So there could be no development. I haven't done anything. And if there was development, as the attorney may have suggested, that maybe sand is somehow development, or putting a pylon in the ground, or having some removable bricks is some type of development, then I would like to have those pictures and have that conversation with the code enforcement officer.
So, Mr. Schilling, do you have anything more you want to tell me?
I'm available.
I'd like to ask that question because he muddled it again. Have the county ever issued a development order for a parking lot? Just a parking lot?
I
Say no.
can't say for certain.
Just say no.
I would imagine we have,
No.
but I can't say yes or no.
Then the answer is no.
No, that's not correct either.
I know, but I can't, it is a no because they haven't. Because I've done my research, this is why I'm here. We can have this meeting next month if you want to answer this question.
You'll get to argue your case.
Okay?
If you have any questions for Mr. Schilling, now would be the time to ask.
I'd like to know because that's better than
All right.
I don't know.
He answered the question, presumably to the best of his ability, and he's not certain.
Okay, well, the county hasn't. I'll enter into the record. That'll be a basis of my appeal. I'll be the first person in the history of Martin County to be cited for not having a development order on an empty piece of land.
Actually, Mr. Schilling's uncertainty concerning
You're
the parking lot.
going to cite me, finding me, and use your power to hurt me on his uncertainty? I mean, let's have this conversation and come back next month.
It is not my
When's the attorney
intent
going
to
concede?
hurt you.
Speaking to you, please be quiet.
Mr.
All right, so
Your Honor, may
let
I
me,
just,
let me ask you one question. Looking at Exhibit 8, look at Exhibit 8, where it says RV camping at 5039, attractions that invite RVers to stay overnight.
Yes. It's called Harvest Host.
Okay. Is that the property we're talking about?
That's my understanding, yes.
Okay, and does it encourage RV camping?
It would appear to, yes.
I accept that. I accept that I have a website on Harvest Host that allows people to park their cars and to stay overnight for free. I accept that, but that's not what this violation, the first violation is about. The first violation is a development order, not a use order. Like we're having a conversation about doing something. This is where it gets complicated. I don't have a structure. I couldn't even comply with the development order because it's a use order. You know what I mean? Like, I didn't do anything. If a development order would remove this structure, take the sand away, get rid of the pylons, I'll do that right now, and I'll be in compliance. And they're arguing that I'm using the property, therefore, if I had just had cars parked here, I wouldn't be here. So why is having, vans parked here? The code says I am allowed, in section 12,
Once again, Your Honor, the
storage or parking of recreational vehicles, including but not limited to boat trailers, camping trailers, these are all allowed, providing that nobody sleeps in them. These are allowed uses in my district. If I just parked those vehicles, we wouldn't be here. We're here because of sleeping in them.
Understand.
But they have no evidence in this case because you removed all those photos.
Understand that development orders do allow uses in some
Uses
cases.
don't imply I need a development order. There's vegetable stands across the county. If I have an agricultural piece of land and I want to put a vegetable stand, I just do it. I don't need a development order. I get a BTR, a business tax receipt. If I could go down to the growth management right now and say, for example, I own the property next door, and I went down, and it used to be a house, and typically you would need a development order, but in the CRA you don't. You just go get a BTR and you're allowed to use the property. The fire department came and put the lights up, and I have my, no, I don't have a development order. Neither does my neighbor who has a veterinarian's office. So to change the use, you don't need a development order because I'm in a CRA. So I can't get one because I go to the office, there's no BTR for me to use my empty lot. So if I could get a BTR and have a business, we wouldn't be here in the first place. But because the county doesn't have anything regarding running a parking lot, I can't be legal.
Okay, and you understand that a BTR, business tax receipt, is not a license. It's not a permission to use the property for anything.
It is for the beekeeper, it is for the vegetable stand.
No.
It is, that's what they use these for. There's tons of lots all over the county.
That's
The
not-
country club, the country club veggie stand does not have a license. Edith's on Solano doesn't have a license.
It's a tax.
I know, but my point is, those don't have development orders, and those properties are being utilized as a use. Those properties do not have development orders.
It's not relevant to this case?
Everything I'm saying is relevant to this case.
Well, I'm sure you see it that way, and I'm sure you want to do what you want to do.
I want to just understand what I'm in violation for. What can I do to the property to become a violation? They want me to change the use, but they haven't asked me to do anything to the property. These are development violations. So what can I do to the property to be in violation? What can I do? I haven't made if I put down millings, for example, and made a parking lot, then they could say, take the parking lot away. I could do something. But I can't go home right now and do anything to my property. I can't look at my property and make any changes. If they want to cite me for use, they're welcome to. But they didn't. The first two violations are development, which there is none.
Well, let me ask you this. Why couldn't you just have all of the vehicles removed and then no longer be in violation?
Well, if that's, I was trying to work with John to show me the code, but as you can see, I think that and this isn't the first time they've done it. This is the amended case. The first time that I got a notice, it was section 3.11. My point is, this is something rare, and I'm used to doing things that are in this scope of rareness. If there was one thing, for example, it's illegal to park a RV as an accessory use. I would be in violation. It's illegal to charge. I would be in violation. It's illegal to. There's a long list of things that I would agree with the county that if I had a public piece of property, I couldn't park the RV on the street, I would be in violation. There's a long list of things that I would agree that I would be in violation. They would have one specific code and they would say this is what it is. But because they don't have one specific thing, they've created three different things. And if I was just parking cars on there instead of RVs, I wouldn't be here. Okay, that's why there has been no other cases in the county opened on parking lots, because I wouldn't be here. The reason is that I'm here is because there's RVs, which I'm allowed to have parking, but the reason I'm here is because they're staying overnight. But that's not a development issue. I'm allowed to park them. So what am I going to do? Go home and say nobody can park on my lot ever again because I lost this case? No. The question is, can they park overnight? We haven't even gotten to that question in the code yet. But I can certainly park cars there. And I can certainly park RVs there. And I can certainly store boats there. I can do everything that I'm allowed because that's allowed.
Okay, and I'm not certain of the issue of being able to park vehicles there.
It's a commercial parking lot. It's permitted use. Table PS5 in the Article 12 says it's using parking lots as a permitted use.
But it's not developed as a parking.
It doesn't have to be developed as a parking lot to park a car there. It's not an airport. I just park a car there like everybody else does. That's my point before the attorney interrupted. Twisted Tuna, the fishermen, the church, everybody uses empty lots as parking lot all over the county. Are we going to have 1,000 cases here? Because I'm going to go talk to every person who doesn't have a development order that parks cars. I have pictures of the church that's in a residential area. They're not permitted to have a parking lot. I don't want to open a case on them. But if my neighbor says I have long grass, then I'm going to tell you that he has long grass too, and we're going to be in a twist-a-fuck.
All right. Let me hear from the county and you've probably had an opportunity to look at the code sections of these violation.
Well, Your Honor, like, once again, I haven't yet finished presenting my case in chief, and we're arguing points of.
You have more.
Oh, yes.
Okay.
That's why we need to go back. This is going to take all day.
I like all day.
I like all day too. But I mean, there's things here we could do if John would just talk to me, which he hasn't. He hasn't reached out to me. The original violation on January
Okay.
3rd, I had a hearing date of
Let's-
January 17th.
Let the county finish their case, okay? Let's let the county finish their case.
Okay, at this time, I'd like to
Do
call
it.
Rachel Spradley.
Ms. Bradley, you've been sworn in.
Yes, sir.
And you're an employee of Martin County.
Yes, sir.
Are you familiar with Harvest Host?
Yes, I do
How are you
have,
familiar with it?
I have the app and I've used it.
So you're a member of Harvest Host?
Yes, sir.
And what is Harvest Host?
So we have to pay a membership fee for a year. It allows you to, if they are registered on there, that you can use their sites to camp on. They are one-night stays that they do advertise on them. What they do is it's no charge. They do ask that you purchase, like there's ones that are wineries, so they ask that you purchase their wine as, part of the deal with being allowed to stay there. And that's kind of what that's set up as.
Okay, so for a member of Harvest Host to stay on any property, they have to pay a fee.
Yes.
To Harvest Host.
So I pay a membership fee yearly to Harvest Host to be part of it.
And is there anything in the Harvest Host membership that encourages members to utilize the businesses providing this or spend any money there?
By the ads, they put on their ads, like the one that we stayed at, like I said, was a winery. So they put on there that they do their own wine making and stuff like that. So it's kind of inferred that they want you to,
You're encouraged.
yes, to purchase their products as an incentive for staying on their property.
No further questions.
Any questions for Ms. Bradley?
Have you ever had to pay a host? Or is that encouraged, or is there any fee for the hosts?
No, other than the purchase.
Exactly. So what it means is that's free. And that's important because the definition of an RV parking lot requires that I collect a daily or rental basis fee, which I do not. So, I mean, I've been on the other side of this where I've had to have, in order to have a food truck, I need to have, an operating business, which is only in the definition. It's not in the actual code. When you go read what a food truck is, but the definition enforces me to do things that are not in the code. You know what I mean? Like it says, a food truck is a business that operates on another business. So the same thing is true in this case. In order to be an RV park, if you look at the definition of RV park, and Mr. Schilling could confer that now, that I'm correct, it says I must charge a daily or rental basis, which I do not. This is a core to the argument because they're saying I have created some type of RV park, and I'm saying I have not. I have a parking lot, and I accept that people stay overnight, but it is not, according to the code, an RV park, and therefore I'm not in violation of that.
Yes, Mr. Schilling. If in fact what Mr. Crowley says is correct, and he does not charge, is it permissible under the county code, in your opinion, to allow vehicles to park on their property?
No.
Under what?
There is,
And-
there are, well,
And why is that?
number one, there is a development order requirement on that property to construct a parking lot.
Which I haven't done.
Number two, the permitted uses do not permit a recreational vehicle park nor a campground on that property, nor does the land use. In fact, recreational vehicle parks are permitted only in several districts, which are commercial zoning districts. I can name them: limited commercial, community commercial, general commercial, waterfront general commercial, and waterfront resort commercial, and PR, which is public recreational. The county has a facility out on Locks Road. There are some nonconformities which were established decades ago that may still be in operation. But the fact of the matter is, a recreational vehicle park and any campground cannot be sited on this property.
Okay?
This is a little bit like Uber or, I don't know, what's another thing? These things I'm doing something that's new. Harvest Host is a new technology. I'm bringing people, my point in general is, I understand why we're here, but Uber was here and, all these other companies were here at the same time and they suffered through it. This is an issue for the county commission to talk about in terms of making the code better. not to cite me.
Let me just caution you again.
Okay.
This is not a conversation, and although you've tried many times to make it that. We're still hearing from the county. I'm asking questions. Mr. Tui is asking questions, and you are able to ask questions at the right time. But you're not presenting your case yet. You're going to get to do that if you want, although you've blurted it out mostly. Let me ask either Mr. Schilling or actually anybody at the county. If Mr. Crowley does not charge, and if Mr. Crowley allows vehicles, in this case, we've seen RVs, park on his property, is there any evidence that these vehicles have parked overnight?
My understanding is yes, several.
Not on this case because we eliminated all those photos.
Your Honor, the photos in the, that are in evidence show numerous vehicles day after day after day, over more than one day.
I dispute that.
And also, if I could, if that answers your question, I have another point I want to.
I don't know that it does, because what I'm, I guess, asking is, are they in the same place? Have they moved? Has anybody observed them parking overnight? Have you, just because you see a vehicle parked in a particular parking space on two different occasions doesn't necessarily mean that it was parked there overnight.
That's exactly correct. Just like your
Well,
own.
I can follow up on that if you wish with Officer Counsel and clarify that point.
Please.
Officer, the RVs that you have observed on the property, were any of these in a, I don't know how to explain, have any kind of stabilizing or disconnected from trailers or anything, showing some semblance of permanency?
Yes,
Okay. And how often did you inspect the property over time? Every day, every other day,
on average, at least every other day.
And when you inspected these on every other day, was there any time that you noticed vehicles that were in a semi-permanent position on one day that was still there on your subsequent inspection?
Yes,
And did that happen more than once?
yes. And on one specific occasion, when the case first started back in January, one of the people who I actually went up to the RV and asked them how long they'd been staying, they stated they had been there a week.
Yes.
And these vehicles that you stated that you had seen parked for more than one day, were any of those vehicles parked on the particular piece of property we're talking about for this case, the southern piece?
Yes.
I think that clarifies your point, Your Honor.
What do you mean when you say semi-permanent? What does that mean?
Basically, there's been, based off the different recreational vehicles I've seen at the property, some have been the motorhomes, which is the one unit. Other units that have been at the property have been ones that are towed in, and they've been completely disconnected from the towing vehicle, anchored and established, where they put out the footers to stabilize the camper separate from the towing vehicle.
So it's like a trailer camper?
Yeah, like a pull behind or fifth wheel.
If I had may I make a comment? No.
Hang on. Can you show me what you're talking? Okay. That's Exhibit 18.
Yes. I'm just using this as an
It
example.
is not in evidence.
Okay. Well, I'm just showing, this is what I'm referring to as one of the pull
It's
behinds.
not in evidence, so please don't refer to it.
That's,
Is that not one?
While I was looking for that, I can make a comment.
no.
This is the type I'm referring to. As you can see, there's no tow vehicle. They've
And that's
they've left this
23.
here, they've parked this here. and
That
the
is in
vehicle's
evidence.
Not attached.
Okay.
Basically, you can see,
So your contention is that that vehicle was parked overnight because it's not attached to anything?
correct.
I'm allowed to store things.
And your visits to this location were close enough in time that you would see, or did you see this vehicle over and over?
Yes,
Your Honor, that photo is not in evidence because that's
Yes,
on
it
the other.
is.
Well, it shouldn't be because the line of the church is,
Number
Yes.
church is right
23.
behind it.
yeah, but the corner line, this angle, this photo's at an angle. That piece of,
It's already been entered in evidence.
that's fine.
It is in
It'll be the
evidence.
basis
I'll
of the
note
appeal
your-
then, that we're
I'll
having
note
this
your
conversation
objection. Okay.
about a piece of evidence that's not on the property.
All right, I'll note your objection. It's,
The list is growing.
you might want to write that one down. It's Exhibit 23. Okay.
But even if it was, it doesn't prove that they're living there. I'm allowed, according to 12.10.07.h,
You
to have storage units.
don't argue your case, okay? You'll get plenty of opportunity to do that.
I'm just saying their evidence doesn't prove that anybody's living there.
All right, so any other witnesses? Any?
Let me ask another follow-up question. Officer Counsel, at any time observing the vehicles that were parked on this southern lot, did you observe any indication of people being present, such as chairs being out, barbecues, people sitting outside?
Yes, I've seen people walking dogs from the campers, and
They'd have portable furniture set up around where the campgrounds were?
yes,
Just like someone's backyard.
Okay. And I wanted to address also the issue of the ordinance as far as rental. Respondent has stated that this requires him to collect a fee. Actually, the definition of a recreational vehicle park in land that LDR Section 3.3 is the commercial use of land to provide spaces for two or more RVs for a daily fee or a short-term rental.
They don't charge.
There is nothing in the statute or the ordinance to require the fee to be collected by the property owner. It just requires that a fee be paid. This is the respondent placed the solicited people on the website from an organization that requires a fee to be paid to use the land. They are paying a fee for a short-term rental, even though they are not paying it. Therefore, it is a recreational vehicle park.
That's a stretch, and this case is getting ridiculous. Well, let's go back to the table and have this case next month. Will you agree that we can have this conversation over a conference table instead of wasting everybody's good time? I'm more than happy to come back, but that argument is crazy. That argument that this membership, which charges whatever I have no control of, I have not collected or do not charge a daily fee. And therefore, according to they're trying to change the name daily fee in order to make me culpable. Like, come on, I'm the citizen here. You're here to protect me.
Quiet. Anything else you want to present?
No. We rest.
Oh, okay. All right, so,
well, should I finish
Mr.
my,
Crowley.
well, I can finish my, let me just finish my.
I'm sorry, I got confused. Yes, we have.
Okay. Based upon the testimony and evidence, I request that Respondent Capital C, Inc. be ordered to comply with the cited provisions of the Martin County Code by February 28, 2024. If not, compliance by then be required to pay a fine in the amount of $100 per violation per day for every day the violation continues thereafter. The county has accrued the cost in the amount of $575 conducting the investigation and request that the county be reimbursed this amount at the conclusion of today's hearing.
Okay.
You're good.
All right, so now we've heard the county's case. Got anything you want to tell me?
Well, let me tell you what happens if on this development order. If I lose, the consequences are I can't use my lot for anything until I go to Paul and say, Paul, can I use it as a parking lot? Which he's going to say, go get a building permit, which I can't get. So they're basically, taking my property from you. So I have a food truck next door, and I do use this property. I'll give you an example. If that's my RV in this picture, which I'm not saying that it is, and I just have it stored there for 3 or 4 days, I may come back here as a repeat offender. I might not be doing anything, and he might just be able to take one picture and say, nobody's living in it, because by section 12.10.07.h, I'm allowed by right to store boats, trailers, camping travel trailers, motorized dwellings as an accessory use, which I argue that I don't have an accessory use, but my point is, like, they're going to take all the rights away because I'm going to have to go to development order, which I can't
Tell
get.
me what that section of the code is.
12.10.07.h, which I'm accused of, development standards and uses, says that if I have a primary use, such as a building, that I can park these things beside my building. They're saying that they've cited me for this, as that and so therefore I must have some.
I was going to ask you what the purpose of letting people park on your property is, and it sounds to me like you're telling me that you have an adjacent use, a commercial use.
I do, yes.
And what is it?
It's my personal office, and on that property, and I've gotten a BTR from Paul and from the growth management, I have one food truck on that property. But it's my personal office, and I have one food truck, and I have a garden. The main reason for bringing them in there is because I'm developing the town, and I'm attracting customers, which when I have 20 people coming from out of town, they go to Krabby's, they go to Basin, they buy the vegetables. And so we're just trying to make Salerno, more popular. I'm not making any profit from this. And if you rule against me, I will not only not be able to invite people to the town to spend a nice time, I won't be able to use my property as a parking lot. And then, so if I park my truck there for 2 days, am I going to get cited? That's what's going to happen if you rule against me.
Well, there are cases and things that, other cases that I have looked at where there was an adjacent use, a primary use, like
But
your
it's not the
office.
same, it's a different PCN. It's not on the same PCN.
Yeah, same situation. And that owner who owned two proproperties together, one that had an office on it with a little parking
Can we
lot.
talk about my case, please? I just would like to rule on this. There's so much to talk about today besides the story of this other person.
You don't want me to explain?
I want you to understand that I'm not charging a daily fee.
I think I understood that. There's no allegation that you charged a daily fee.
Yes.
There is an allegation that through Harvest Host, people paid money to actually be on the property because they paid a subscription.
And therefore, I'm culpable for that.
That's pretty tenuous. And,
Thank you.
and so, I'm trying to look at the evidence here.
I'm trying to present the evidence, even though I'm passionate about it, because I feel it's been a lot of work for me, and I've had to.
And as you can see, I'm
patient with
this passionate about it.
No, you're very patient. Thank you.
I'm just trying to understand the case. Trying to understand the county's case, I'm trying to understand yours, but you're not giving me much opportunity here.
I'm sorry.
so-
I'm just upset about the whole thing.
Okay. All right. So back to my analogy. If you had two parcels, and you do, there are many examples of where the county has successfully brought cases where somebody would have a primary use and then use their adjacent property without a development order for some other use that was not allowed.
But never parking lot.
No, some of them have
No,
been
never.
parking lots.
No, never. There has never been a case brought here for a parking lot that has had no development order.
Au contraire, and maybe it was some other section of the code, I'm not sure, but you've got permitted uses, and that's
But mine's
a
permitted.
problem.
Mine's permitted. Table PS5 of Article 12 says mine's permitted. Okay, your point about people parking on a lot that's not permitted, yes. The church does that now. The church is in the residential sub-district, and they have a big sign that says parking only. I don't want to open a case and tell the church they can't use their parking lot.
Let me ask the county. Permitted use in the Port Salerno redevelopment zoning district. You've cited section 12.6.03.2.b, permitted uses. Is your contention that the use of this vacant lot for parking is not permitted?
No.
It is
The
permitted.
reason we use section 12.603.2B is because we're saying that the use of the property being used as a campground.
He asked the question, just answer the question.
I
Parking
am,
lot.
I am.
Yes or no? He asked about parking lot, and then you
No,
start talking.
he's asking why we use the
He asked you
code.
to stop.
That code, the reason we use that code is because the permitted use of a campground recreational park is not allowed.
If you ask your question again, he hasn't answered your question.
All right.
You asked if parking is permitted.
And how do you get to campground through you get to campground through Exhibit 8?
That's part of it, yes. That's one of our exhibits, was that he advertised it as a campground. There's RVs, people camping in RVs on the lot, so therefore, the reason we use that code is to say a campground / recreational vehicle park is not a permitted use for this property within the CRA.
Because your contention is that Mr. Crowley is attracting RV camping. Says RV camping.
Correct.
But their evidence for overnight parking is based on a long series of questions from the attorney. The proper question would have been, have you been there overnight and taken pictures? The answer is no.
Well-
I can park my RV every day in the same spot and take the same pictures and have the same evidence, and that doesn't prove that I see
Because
it.
the same exhibit says that there are wineries, breweries, farms, and attractions that invite RVers to stay overnight.
Thousands of them all over the country. It's very popular, and it's a blessing for the community.
But this is your ad.
No, that's the Harvest Host ad. Harvest Host says we have thousands of places. Normally, it's a winery or some place that has a lot of land that says, hey, why don't I have RV park here? It was a good idea 20 years ago. Somebody came along, created a website. But it's like I said, like Uber and these other sites that are new, and now people like myself said, hey, this is a great idea. I can bring people to the community to spend money. I don't have to build buildings. The idea is that I'm not trying to build infrastructure because I don't want to have to build buildings. Once I start coming to the development review, I've got to build a $4 million building. I'm trying to use the things in a very soft way, which the community wants.
So you had nothing to do with
No.
the creation of this ad?
No, I created the ad within the application. I posted this photo and a couple other photos.
Okay, then
But-
I defer to Exhibit 9, which is the ad that he testified that he posted.
Yeah, this is my ad on a website that does this for thousands of people all over America.
Does it or does it not say primitive camping?
It's not about what,
Does it, or does it, yes or no? Yes or no, sir? Does it or does it not say primitive camping?
I didn't read it, but I'll take your word for it. The point of it is, a series of photos in the afternoon doesn't prove overnight sleeping. It proves that maybe the car was there, because you can infer that, but I can take the same photos maybe of his house, where he has an RV next door. It doesn't mean he's sleeping in it, it just means it's parked there for a series of nights. These people oftentimes travel, they get in the middle of the night, and they come around, they park in the same spot, because that's what people kind of do. There's no proof here. And the second thing is there's no proof that I'm accepting money. The proof that they're offering and the evidence that Rachel gave are that it's free. The attempt by the attorney to extrapolate that I'm somehow benefiting from a $99 service paid to some other website is very tenuous, as you mentioned.
Okay, so then looking at Exhibit 9, which you posted, which says primitive camping, best for self-contained campers, no toilet, showers, or portable water at this hip camp. 1.25 acre vacant lot, leveled with crushed rock and shell and grass, fire pit, no hookups, 2 blocks from Manatee Pocket, lots of restaurants nearby, an excellent Latin market, vegetable stand, beautiful breeze. It's the kind of spot that you can get comfortable in. It is my lot. Please text me at this number to let me know you are staying. I'm not charging anything at the moment, but my intent is to gather feedback about the location and demand, blah, blah, blah. And then it tails off.
That's exactly my intent. I'm not charging anything.
Okay, so can this be an RV camp as you've advertised it?
No, it can't, because the definition says I must charge a daily or short-term basis, and it says very specifically, I'm not charging anything. I'm saying come enjoy the community, go spend your money, and that's what these people do. These are $500,000, sometimes $250,000 vehicles, more expensive than people's homes. When they come here, they want to go to the seafood restaurants. The reviews, I have 90 reviews in 6 weeks. They're raving. I wouldn't have 90 reviews if more people. The RV community is very connected. You know, I get eviscerated in the paper as, you know, not having good PR, but that's only with the angry locals. More broadly, I have excellent PR. You can go talk to anybody who's staying here and say, my God, I love this place. I have never known Port Salerno, and I love it. So there's another side to this whole thing that's much bigger than, you know, the political. The reason that we're here in the first place is because 60 people were organized to complain. They were additionally organized to honk horns and so forth. To my argument, more broadly, this is a political issue that we should go and talk about fixing the code. You know, we have to go through this first, but I hope you see that
You know,
this is bigger.
you're welcome to do that, of course, but I have to deal with the code that exists.
I understand but I'm making a point, and I hope that my passion doesn't hurt my argument, that very specifically in this case, I cannot be a recreation. We can resolve this one piece if you'd like. You can rule if you'd like that if I am indeed a recreational park. If I am indeed a recreational park, to your ruling, I have two choices. I can either go back with, you can give me some time to comply, and I can work with the code enforcement officer. And what would my compliance be like? It would be to tell everybody to go away, stop advertising, and, you know, and end it. It's very simple for me to comply. I'm not charging any money. I don't lose anything. The second option would I go to the circuit court because I feel aggrieved, which I may, depending on the evidence. And the weight of the evidence here is one tenuous argument from the lawyer that somehow I'm benefiting from a $99 fee versus all the other evidence from Mrs. Bradley to myself to the ad on the paper that there is no fee. And if there is no fee, therefore there can be no recreational park.
Okay. Understand that I have not seen or heard anything about this case
I understand.
prior to this morning.
That's why I'm focusing on this one
So
definition.
you know what you know because you've lived it. The
Understand.
county knows what it knows because it's lived it.
That's why we're focusing on this one line.
And unfortunately, that does not transcend to me.
That's what the circuit court's for sometimes.
Well, no, I mean, I'm happy to hear this case and to continue hearing the case. The problem is that I think I'm going to need a little bit of time to digest. So I'm looking at this. I'm not to the point where I can clearly find a violation, and I'm not to the point where I can clearly say,
I accept that.
you're right. I can't say that either.
I don't even know that I'm right until we go through the process.
All right.
This is what this is for.
I also think that that we probably should resolve this not a month from now, but sooner. And so what I'm thinking is that we ought to look at our calendars and come up with something in a 2-week kind of time frame where we can hear the remainder of this case.
Well, Your Honor, if I might interrupt you, please. We've been sort of distracted by this RV park, but that's just one part of it. The evidence clearly shows development activity.
No, it doesn't.
There's been pilings put in the ground, there's been structures put in, there's been fill put down. That's development.
That's
The
not
the property, the subject parcel is in violation. It has no development order.
Then I'll take those out.
Besides the
Now where we are.
besides the parking issue, it needs a development order for those things there. The parking issue itself, the RV park is one part of it. Just parking, if it's an empty lot, that's all it's allowed to be used for.
That's not
You
true.
couldn't park anything on the empty lot. It would be storage.
That's not
It's
true.
not allowed.
Every other commercial property in the county is allowed, except for me. There's never been a case brought.
Your Honor, we may be allowed to talk. So
I think I understand what you're saying, but in fact, the question, I guess, is whether or not you could improve the lot to any extent. Can you put a fire pit on it?
Yes.
Can you
With
allow,
sand. Yes. If I need to take those off and be in compliance, I'll go do it now. What am I going to do with the sand? I'll move the sand to the next space on the lot. It's a sand. I mean, it's crazy. What he's saying, not only is it tenuous, it's crazy. Like, it's just insane. If there was a building on the lot or anything at all building, this is pylons. This is landscaping. This is not improvements.
but can you improve the property at all without permit? I haven't really heard any clear evidence on that.
We, by design, did not bring a 105-1 violation for that, in case the respondent does want to apply for a development order for something that would be allowed on it. The compliance in this regard would mean you leave that stuff is there until such time as the development order is put in, remove the RVs, have no more overnight parking on the lot, return it to a vacant lot, which is all that it is allowed to be used for, absence of development order.
That's not true. Otherwise, every other vacant lot, including the Twisted Tuna parking lot, the church's parking lot, where the fish boats, all of those vacant lots, where the cars for, every vacant lot would have to have a development order. As long as I'm permitted, I can park cars there, which I am permitted, which Paul wouldn't say yes directly, but it should look it up, and the answer is yes.
May I add?
But let me respond to this mixing up permitted uses with authorized uses. The permitted uses in the zoning is merely a laundry list of the things which would be allowed and things that are not allowed. Excluded is RV parks, allowed is parking lots. But you have to then apply for a development order. Development order then leads to whatever necessary permits, grading, fill, et cetera.
I'm past you guys right now. I'm looking at Wednesday, the 13th. Can we find out if this room is available? We're going to do that and see if we can get everybody back here.
Can you make some specific rulings to narrow this down a little bit in terms of what they're going to be talking about? So
I am going to require you all to meet prior to that time to see if you can stipulate to any facts or the law.
I would
regarding
like
it.
that. I would like that very much if we stayed to the law.
And in the meantime, I'm going to ask that, that I get a copy of all of the evidence, not the ones that I've excluded, just the evidence that is in.
And I would request we do this in 2 separate cases with distinctions and
We are.
surveys.
We are.
Okay, well, we haven't so far, because there's still pictures in here that are not appropriate for this lot.
I asked you specifically about that, and you said, oh, I object to everything.
Yeah, so that I can appeal it when you guys include.
Well, no, that's,
I didn't accept the evidence, and therefore it has to be accepted. I said, they presented things, I don't know the details, I don't have a survey, but if you want me to accept it generally, then let's move on to the next thing. But I don't have the tools to understand even where those pieces of property are.
what I would like you to do is be able to articulate any objection to each piece of evidence.
Yes, and that's what I'm saying is that the county we should work together, I hope, and I'd love to work together. I would love to sit down with Paul. Paul's a very busy person.
The 13th available,
Yes, sir. So I have her booked right now from 9 to noon on the 13th.
okay. All right. I'm going to continue this case and the case that follows, the case ENF 2024-010059 case. I'm going to continue both of them until 9 a.m. on the 13th. And I'm also, and I'll issue an order to this effect, that requires the county and you to meet prior to that time to see what stipulations you can agree to as far as fact or law. And if we can narrow that down, I would also invite either of you to submit anything you want in writing regarding the law or the facts prior to that time.
And submit this document.
So you have a document that you want submitted.
You know, that's
Okay.
that's what you were going to ask for.
Okay.
I gave it to them already.
I was provided with a copy at the beginning of the hearing.
All right. Any objection to
No.
this? Let me just take a look. All right. Is this basically your case in
Yes.
writing?
That's exactly right.
Okay. All right.
Now, there's some
So-
things in here that I wrote this not having access to the photos. So a big part of my thing here is I don't have any evidence. And so my point is, how was I supposed to comply? Like, for example, if the attorney would have sent me a photo of my fire pit and said I have to remove it, I wouldn't be here now. I would have already complied. But I wasn't given any photos. These photos of these RVs, I mean, I could have parked them someplace else. I wasn't given any chance to comply.
You're going to have, I think, that opportunity, and you have, theoretically, you have, because you've gotten notice as a violation. And
Theoretically.
that normally prompts a
but I-
respondent to say, gee, the county must think I'm in violation
I know
here.
they think that, but we're
Find-
here.
And then find out why.
I know, but we're here because I've read the rules as well.
Okay.
And
All right.
I'm the law's for the people, not for the government to abuse me with it.
All
I
right,
thought it looked-
without objection, I'm going to accept into evidence the respondent's exhibit. It's 3 pages, dated February 21st, 2024, just simply titled Magistrate Hearing, Martin County, Florida. And I'm going to mark it as Respondent's Exhibit 1. And that is also in evidence.
Thank you. And,
All
but my point was, because I didn't have the photos, some of my arguments are about lack of evidence. So when you read this and so forth, you just have to take that into consideration.
All right, so here's the deal. What I would like for the county to do is produce copies of all of its evidence, only the photo exhibits that were permitted. If you have any question about that, I've got the list. And all of the remainder of its exhibits. And send a copy to Mr. Crowley, send a copy to me, so that I have it well ahead of the 13th. Understand?
And a transcript of our meeting would help you as well, maybe, or some results.
I think I've written enough notes for that. I don't need a transcript, but, and it's available, the video will be available to you anyway, so.
My reason I asked that question is, I would like nothing more than to resolve this today. Maybe we can go to the office, and that there's no need for you, because this has been a conflict, and we've come to you as a mediator in some ways, not as a judge.
Except that's not my role either.
I know, but I'm asking if you could compel the county that we could
Your
come
Honor,
to a
just for the record,
resolution.
we've had voluminous contacts with the
We- no.
respondent, explaining what the violation was and how to come into compliance.
No, there has been, you mentioned removing sand may possibly, there's no document that said, you just inferred and you wanted to color me with that.
All right.
That was unfair.
Mr.
Okay.
Nicoletti?
We've been on this thing for an hour and 20 minutes, and I think that's enough.
I have a
Ma'am?
question. Can you tell me again what exactly you want me to send?
Say it again.
What exactly do you want me to email to you guys?
I would like,
Could you try again?
oh my gosh, quiet. I would like a copy of all the evidence
Okay.
And me too.
and a copy to Mr. Crowley, but I don't want, obviously, the exhibits that have been excluded.
Okay, so you want me to send for this case that we just heard, the exhibits that you accepted?
Yes?
And then for the other case, you want me to send you everything?
Yes.
Okay,
And to Mr. Crowley.
yes.
Okay. Understand that the second case, nothing's in evidence at this point.
I understand.
Okay. All right.
Do you want to set a date, Your Honor, for the submission of that and any written,
Well, can that be done by Friday?
Yeah.
the 8th?
All right, so by the 8th, you're going to submit evidence. All right, and no. Where are we?
We can meet today. I mean, there's also a meeting
on.
pending.
No, I meant by the 15th. Submit the evidence.
Well, you're,
Your
Doing-
hearing's on the 13th.
Wait a minute, hang on. Wrong date, 23rd.
okay.
23rd.
So by this Friday, you want-
This Friday, send the evidence out.
Okay,
and what about any written memorandum?
Yeah, that by the 8th.
Okay.
And if we can meet by Friday and you can compel the county to do that, that would be helpful.
Mr. May I?
All right, I'll draft an order and hopefully email that out to you. Do we have a good email address for you?
Yeah, John has an excellent email address for me.
Okay.
And if, yeah,
Mr.
Your-
Nicoletti, Mr.
Your Honor, may I just, for practical sense and purposes, give you my opinion on where we may end up here?
No,
Okay,
no.
thank you.
No, I mean, obviously, you want to share that with your staff and with the county's attorney, but no, at this point, I mean, unless unless what you've got to tell me is actually probative and will resolve it, then no. I'm not to a point where I even understand enough of I think I understand the facts. What I don't understand is whether or not any of that constitutes a violation. And so that's really what I want to focus on. And I will do that.
Thank you.
Because that's basically Mr. Crowley's contention, that, yeah, sure, I've got RVs on the property, and so what? I'm allowed to do that, and I can use my property basically the way he has so desired.
That's
So-
exactly right.
Okay.
The purpose of my comment was to, in essence, and then I'll be quiet, is in essence that there is no method to authenticate or authorize an RV park on what could be considered a parking lot. So, and I don't have that jurisdiction or ability to get to the point that that would ever happen.
Okay, but the county commission does, right?
Yes, sir.
Okay.
There we go. I like that direction. I believe this is a political issue, as Uber was, and a lot of other sites. Airbnb is a good example. Became and went to the state capitol. So this is just something that's a reverberation for something that's, I think even Rachel, because she uses it. Everyone would agree. I'm not harming anyone.
I want to look at the 3 sections that have been charged
Yes, of course.
and see if I see any basis for the charge.
Thank you. That's been my intention. I freely admit to the facts. I'll vehemently oppose Mr. Tooney's attempt to tenuously attach payments, overnights and things like that. Let's just stick to the facts about what I'm doing. I'm more than happy to admit them.
I mean, normally, in other cases, there might have been, and had you been represented, there might have been a motion to dismiss early on based on something. I've
I'll bring an
kind of
attorney with me next time.
heard it, but I
I'll bring an
haven't been able to actually
I
see
understand. My
it.
apologies.
So,
Be more professional.
okay. All right. Okay. So those 2 cases are now continued, but I will get an order out today, hopefully this afternoon sometime, maybe tomorrow morning, that formalizes that, and then we'll go from there. All right. Okay. My apologies to folks who are here for cases that still have to be heard. It's unusual that we have any case that goes this long, but we have today. The next case I'm going to call is, respondent is Robert Sweat. It's ENF 2023-100568. And anybody here on behalf of Mr. Sweat? Room is, okay, thank you. It's Robert P. Sweat. All right,
Got him.
thank you.
No, we got him. He's right here.
Okay, my apologies. As I was saying, maybe you didn't hear me, but
People getting up to.
But in fact, it's unusual that we have a case that goes an hour and a half, and especially one that isn't resolved. All right, this is case ENF 2023-100568. And Mr. Sweat, this is also a violation case. We're going to hear from the county. As I think you were here in the beginning when I talked about if the county makes a prima facie case, then the burden flips to you, and then we'll go from there. You can tell me what you need to tell me. All right, and let's see, this is Officer Fisher. If you'll raise your right hand, do you swear or affirm the testimony about to give will be the truth, whole truth, and nothing but the truth, so help you God?
I swear.
All right, so we're going to hear, you can stand there if you like, or you can sit down and look at the monitor that's up on the wall there. Okay.
Morning, Your Honor.
Morning. Oops. Miss Bradley? I need your help here. Great, thank you. Hang on just a second, Officer. Okay, I'm with you.
My name is Nicholas Fisher, and I have been sworn in. I'm a code compliance investigator for Martin County. Respondent Robert P. Sweat is present. This case concerns the property at 8617 Southeast Oleander Street, Hope Sound, Florida, 33455 in Martin County, Florida. This case was not generated from an anonymous complaint. According to the official records of the property appraiser of Martin County, property owner, excuse me, property owner is Robert P. Sweat. A copy of the property appraiser's record of ownership is County's Exhibit Number 1. On October 20th, 2023, I inspected the property. At the time, I observed new windows/frames installed without a permit and trash and debris on the property. At that time, I photographed the property. The photographs accurately shows what I saw then and is marked as County's Exhibits Numbers 2 through 6. Exhibit number 2, a front-facing view of the property with the new front exterior window and some trash and debris, building material in front of the white van. New window here and here.
Okay.
Exhibit number 3, just a left exterior view of the front of the property. Oops. Exhibit number 4, just a close-up view of that trash and debris building material. Exhibit number 5, front-facing view of the entryway to the front door of the property. Trash and debris here as well. And another new window right here next to the front exterior door. Exhibit number 6, the door tag I left to get in contact with the respondent. I've also attached a screenshot taken from Google Street View dated January 2015, depicting the previous windows marked as County Exhibit Number 7.
Okay.
And as you can see from the screenshot taken, these are older windows. Based upon the investigation, I issued a notice of violation to Robert P. Sweat on November 22nd, 2023, marked as County Exhibit Number 8. In the notice, I cited the following Martin County Code violations: Section 67.201, subsection B, nuisance declared trash, General Ordinances, Martin County Code, and Section 105.1 of Florida Building Code, permits when required incorporated by Section 21.1, General Ordinances, Martin County Code.
Okay.
In the notice of violation, the respondent was given until, I forgot the exhibit number 8, the notice of violation. In the notice of violation, the respondent was given until December 22nd, 2023 to correct the violation, was informed of the need to contact Martin County Code Enforcement upon doing so. Compliance was not achieved, and a notice of hearing was issued by certified mail on January 22nd, 2024, and is marked as County Exhibit Number 9. Exhibit Number 9, the notice of hearing.
Okay.
The return receipt was not received. Therefore, on February 5th, 2024, I posted the property with a copy of the notice of hearing. A photo of the posting and the affidavit of posting are marked as County Exhibits Numbers 10 and 11. Exhibit number 10, the posting on the front door of the property there. A junked appliance. Exhibit number 11, the affidavit of posting. No call or letter from the property owner was received within the time allowed. Therefore, I went to the property again on February 20th, 2024, and saw that the cited violations had not been corrected. At that time, I photographed the property. The photographs accurately shows what I saw then. It is marked as County Exhibits Numbers 12 through 14. Exhibit number 12, the same front-facing view of the property with the new windows and building material, trash and debris. Exhibit number 13, bag material, trash and debris. Exhibit number 14, that front entryway to the front door showing that the posting was removed. I have also attached a screenshot showing that no permit applications have been filed for the new windows, marked as County's Exhibit Number 15. And this was taken on February 20th as well. Just showing that no permit applications have been filed or pulled for the windows. I request that all the county exhibits be received into evidence. Based upon the testimony and evidence, I request that the respondent, Robert P. Sweat, be ordered to comply with the cited provisions of the Martin County Code by March 29th, 2024, and if not in compliance by then, be required to pay a fine in the amount of $100 for every day the violation continues thereafter. The county has incurred a cost of the amount of $575 conducting this investigation, and request that the county be reimbursed this amount at the conclusion of today's hearing.
Okay, Mr. Sweat, you raise your right hand. Do you swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Your full name and address.
Robert Parody Sweat,
And your address. Address.
8617 Southeast Oleana Street, Hobestown, Florida.
Okay. All right. And you are the owner of the property.
Yes.
All right. And you've seen now the county's exhibits. Any objection to my accepting items 1 through 15?
No, you're right. Just
Okay. So without objection, I'll accept in evidence the county's exhibits 1 through 15. Anything you want to tell me?
I thought I could install a window because it wasn't impact, because that's all they asked for, it's impact. I'm just installing a thermal window from a single hung window. And I didn't think I didn't know that I needed a permit to
Okay.
replace.
Okay, and now you do.
Yes, I do.
All right. So but you haven't made application yet for the building permit?
I was going to do it this morning, but I wanted to get here on time.
Okay, that's a good thought.
And I wanted to make sure that if I pull a permit, I pull a permit for the windows in which, because I thought it was just the two front windows you had an issue with.
Okay, no, it's any new window that, even replacement windows do need permits. Okay. All right. Well, all right, what about the trash and debris and stuff that's around the property?
The trailer that sits there,
Exhibit,
it's got tarps and supplies on top of it, but that's what he showed. Or is it the rocks that are by the tire?
let me see. I'm going back to,
Just all the trash and debris that you can see, Your Honor.
all right, that's Exhibit 13.
Correct. And it's shaded, but any building material, bricks in front of the van.
The edging for the road for the.
If it's any sort of building material, it's classified as trash and debris unless you have a permit pulled for that, or if you're in the process of,
For edging of the.
if you're in the process of decorating something and it's out there, that's generally fine, but if it's just sitting there, stationary, not moving,
Being installed, okay.
yes.
So you've got a couple of trailers there. You've got the closed trailer. And I don't know,
The AC unit, I'll move it from there. I'll put it to the road.
Well, you've got a lot of things going on, and some of which,
Chairs?
Chairs are fine.
and chairs are chairs, and that's not an issue, but you do have a lot of other things around that look like outdoor storage of,
Trash cans?
Not trash
You
cans.
got it the day that somebody had brought my recyclable up there instead of putting it up there to the house. You talking about the bricks there?
Correct.
You got bricks, and you've got those clay pots, and you've got other
Clay pots?
things that are just, and I'm not going to enumerate them because
Okay.
it's not up to me to tell you what to do here. It's up to me to see if there's a violation, and I frankly do see violations of the code, both for the lack of a permit and the trash and debris.
Okay.
And it is up to you then to get with the county and find out what it is you have to do to come into compliance.
You're right.
Okay, all right. So without belaboring it, I'm going to find that, based upon the evidence and your testimony, Mr. Sweat, and the county's testimony, that violations as charged do exist on the property, and I'm going to order you to comply on or before March 29th,
Okay.
2024. So you've got over a month to comply. Failing which, I am going to fine you in the amount of $100 per violation per day. Theoretically, you could come into compliance with one and not the other. But understand, if you're in violation of either of them or both of them, the fine still applies. And so it could be up to $200 if you're in violation of both, or $100 if it's just one. So it's per violation per day
After the 29th?
after the 29th. So beginning on the 30th of March.
Okay.
All right. And based upon the costs, I'm going to award costs in the amount of $575 to be paid to the county at any time after this order is rendered. So, gosh, okay. You actually could have avoided maybe some of those costs had you gotten with the county and stipulated to what I think you already recognize was a violation and is a problem, so. And the cost, instead of being $575, would have been about $300. But we're unfortunately beyond that, so. All right, do we have an email address for you?
Yes.
Okay, have you already given it to
No, I
the
haven't
county?
given it to anybody.
All right, just give it to the county. It doesn't need to be as part of the public record, but, or not for this hearing.
No, thank you.
I mean, it does become public record, but give that to them. They can email the order finding violation to you. But I think you've got the gist of it, and we'll go from there. Okay, good luck. Make sure they've got your email.
Thank you, Your Honor.
Okay, thank you. All right, let's see. The fourth case is the Gerson case. Anybody here on behalf of Eric or Gabriella Gerson?
I marked the wrong one. I'm sorry. No. I wrote on the wrong one.
Gerson is off?
Yes, sorry.
It's just
It's
not?
just not the one that.
Okay. All right, so I stand corrected. Thank you, Ms. Bradley. The next case I'm going to call is MCFL Holdings LLC. And, sir, are you here on behalf of the corporation?
Yes.
Okay. All right, so this is case ENF 2023 030456. The respondent is MCFL Holdings LLC. And Ms. Switzer, you're going to testify.
Yes.
If you'll raise your right hand, do you swear or affirm the testimony about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, and this is also a violation case. Let me grab the right document. Okay. All right, whenever you're ready.
My name is Kelly Switzer, and I have been sworn in. I'm a code compliance investigator for Martin County. The respondent, owner of MCFL Holdings LLC, is present. This case concerns a property at 1235 Southwest 34th Terrace in Palm City, Florida, 34990. This case was not generated from an anonymous complaint. According to the official records of the property appraiser of Martin County, the property owner is MCFL Holdings LLC. A copy of the property appraiser's record of ownership is County's Exhibit 1. On March 21st, 2023, I received a case for an expired permit application for a new fence. After inspecting the property, I found that the fence was installed without an approved permit. At that time, I photographed the property, and the photograph accurately shows what I saw then as marked as County's Exhibits 2 through 4. This is the expired permit letter,
Okay.
number 2. And then there's the installed fence, 3 and 4.
All right, and who is this being addressed to?
The letter,
Yes, ma'am.
actually, it's probably the contractor for the record, because there was originally a contractor on file who was no longer involved.
All right, wait a minute now. So Danielle Gashel,
Would be the contact for the original permit application
All right.
submittal.
okay. All right,
Based upon the investigation, I issued a notice of violation to MCFL Holdings LLC on March 23rd, 2023, and is marked as County's Exhibit 5. In the notice, I cited the following Martin County Code violations: Section 105.1, Florida Building Code, permits when required, incorporated by Section 21.1, General Ordinances, Martin County Code. In the notice of violation, the respondent was given until April 24th, 2023 to correct the violation and was informed of the need to contact Martin County Code Enforcement upon doing so. Compliance was not achieved, and a notice of hearing was issued by certified mail on May 15th, 2023, and is marked as County's Exhibit 6. The owner contacted us requesting time to receive approval with the Growth Management Department. Therefore, an amended notice of violation was issued via certified mail on January 11th, 2024. The amended notice to appear is marked as County's Exhibit 7. The return receipt was not received, therefore I posted the property and at the Martin County Administrative Building. The photo of the posting and the affidavit of posting is marked as County's Exhibits 8 and 9. The application with Growth Management Department for a special variance has not been submitted, therefore I returned to the property on February 20th, 2024. The fence still remains on the property, and the photo of the fence is Exhibit 10. This was just yesterday. The permit application still remains in expired status. A screenshot showing that the permit application permit status is marked as County's Exhibit 11. Based upon a testimony and evidence, I request that all the county's exhibits be received into evidence, and I request that the respondent, MCFL Holdings LLC, be ordered to comply with the cited provisions of the Martin County Code by March 29, 2024, and if not in compliance by then, be required to pay a fine in the amount of $100 for every day the violation continues thereafter. The county has incurred a cost of an amount of $575 conducting this investigation, and requests that the county be reimbursed this amount at the conclusion of today's hearing.
all right. What about what was marked as Exhibits 3 and 4? We actually didn't really,
This is the fence in question being installed. That's installed, that's on the property.
okay. Is the installation complete?
Correct.
All right, and so, but the permit application was there. Was the permit ever issued?
No.
Never got that far?
Correct.
So it wasn't paid for, wasn't picked up?
Correct.
Okay. All right, okay, I think I understand. All right. Sir, come on up to the podium, if you will.
Hey, good morning, Jeremy Lemaster for the record.
Mr. Lemaster, if you raise your right hand, do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yep.
Okay? And your full name again?
Jeremy Lemaster.
And your address?
I'm the owner of this, 1235 Southwest 34th Terrace.
Okay.
So we originally hired Daniels Fence to do the permitting, do the fence, do everything. From what I understand, that they did it but didn't obtain the permit, which we didn't know about, which then got in contact actually with Rachel and the CRA, and then tried to work out some of these kinks. Then they kept on throwing it back. From what I heard with Daniels Fence, that CRA was saying, hey, you can't do a chain link fence, I believe, is what they were trying to say. Okay. So we're like, okay, well, why did they do this? And I mean, it went back and forth, and then sometime during the record, Daniels Fence said, you know what, screw it, I'm just going to pull it myself and not be a part of it, which I don't know how they can actually do, but regardless, so I'm here trying to get, clarity on what we're actually going to be doing. We submitted for the complete variance submittal this morning. I've had multiple meetings actually with Susan on other projects, and we've mentioned about the fence, but there's never been like any kind of resolution of what we're actually doing, other than she's just said, all right, I think we're all clarity what it is now. Let's just get it all submitted, and we'll just review it and be done.
All right, let me ask the county, is there an active case against Daniels Fence?
No, not at this time.
Okay. All right. So, and this really occurred, what, a couple of years ago?
Yeah, it's been going on for years. So I mean, we paid them, I don't know, $13,000 or something to literally do it, be done. So I didn't have to do it. I could just take care of my other stuff for my other corporations. And we get stuck with this. And I mean, you guys can see the Daniels Fence signs right there on the left post. Trying to clean this up. We're surrounded by chain link fence on the other 2.5 sides, but regardless, I'm not going to argue that. I don't care about that. But
So-
CRA is going to review our what they call alternative compliance, and then we should be taken care of from there.
Okay. All right.
And I talked to them this morning again also.
And you say you're testifying that you have filed that
Yeah, I turned it
application?
in to Barbara, is that it?
All right. Ms. Bradley, you've joined the conversation. You've been sworn in.
Yes, sir. So I actually just went over and spoke to Barbara Counselor, who takes in the alternative compliance paperwork. She does have the application, so it is pending at the moment. There is one other thing that Mr. Lemaster needs to take care of in order for them to put it through, and then once he does that, they'll get it to the review process for everybody.
All right. Let me ask the county, any reason I shouldn't continue this case? Because it looks like it could just go away if the alternate compliance variance is granted.
We would have no objection to that.
All right. All right, so I'm going to continue this case to the March hearing.
I think it's the 20th, March.
Rachel, how long do you think it'll take them to make a decision?
Do you know what they wanted, Rachel?
Yeah, you need to get the barbed wire off.
Oh, to take the Barbara, okay, all right, that's fine.
I would probably give him until April, honestly, because I think it's a 30-day process, so I think it's going to put him,
Go before the CRA board.
it has to go through, no, it doesn't go, it's just a review decision that they have to make. So it's 2 different departments, I believe, that have to review it.
All right, I'm going to continue the case then to April 17th. And just as a matter of record, I'm not going to physically be here on the 17th,
Yes.
but I've asked Magistrate Werb if she would take those cases. So
Okay.
April 17th, and we'll continue the case, and I'll get
I'm sure it'll be resolved way before then.
and I'll get you an order out. Do we have an email for you?
Yes, they have everything. I'm shocked as a contractor myself that the contractor can just be left alone.
I am,
So I can answer that for you.
Yeah.
It's Daniels Fence is a state certified contractor, which it has to be brought before the state. So Jeremy would have to file the complaint through the DBPR with the state. We don't really go after state contractors because we don't regulate them.
well, if in fact they abandoned the work the way you are contending,
They submitted letters to Rachel and I mean, it stinks. And Rachel and them, they did a good job. That's not about them at all. And, you know, it's just stinks that, you know, they didn't have to clean up their mess and they were kind of just left, you know, I was left hung out to dry and figuring it out. I mean, we tried to, you know, Rachel will know this. I mean, we tried to schedule many meetings with CRA over and over and over. And we have that in black and white. And I mean, honestly, I don't even know why we're here. That's a question for Kelly.
well, because
but-
it's an open case.
No, I know, but there's a lot of stuff that's been going on in the background that everyone's all very, very aware of.
All right, I would think you may want to consider filing that complaint, but,
Mr. Nicoletti also going to put on record, if he does come into compliance prior to April 17th, that we will just go ahead and close everything out and won't bring it back.
of course. Okay. All right, good. Hopefully you get it resolved. Thank you.
I want it resolved too. See ya.
All right. Oh, you know what, Mr. Lemaster? I'm sorry. Will you come back to the podium just while you're here? The exhibits, did I ask you if you had any objection to exhibits 1 through 11?
I don't believe so, Your Honor.
Do you have any objection?
No, I mean,
All right.
it was, yeah, it was clearly done.
Because that actually helps
See,
clarify.
I mean, what
the-
actually happened was they were going off of whatever code, well, then the CRA code trumps they have their own separate code. So I think that's where the miscommunication happened when they were doing the permit, when they sold the job to me. And then that's why we're in all this mess now. With the
Okay.
chain link fence opposed to,
Yeah.
you know,
The CRA is an overlay in that district, yes, okay.
So-
All right, so without objection, I'm going to accept into evidence the county's exhibits 1 through 11, still continuing the case until April 17th.
yeah, that's fine.
Okay,
All right,
thanks.
thank you, guys.
All right, let's see, McDonald's. All right, Officer Ambrosetti, if you'll raise your right hand, do you swear or affirm testimony about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Yes, sir. All right. And this is case number ENF 2023 090258. McDonald's Corporation is the respondent. Um, 058.
My name is Charles Ambrosetti, and I've been sworn in. I am a code compliance investigator for Martin County. The respondent, McDonald's Corporation, is not present. This case concerns the property at 2900 Southwest Martin Downs Boulevard, Palm City, Florida, 34990. This case was not generated from an anonymous complaint. According to the official records of the property appraiser of Martin County, the property owner is McDonald's Corporation. A copy of the property appraiser's record of ownership is County's Exhibit 1.
Okay.
On September 11, 2023, an expired permit letter was emailed to the contractor of record. A copy of that letter is marked as County's Exhibit 2. This was the expired permit letter emailed to Air Care Services.
Okay,
Based upon the investigation, I issued a notice of violation to McDonald's Corporation on December 12th, 2023, and that is marked as County's Exhibit 3. In the notice, I cited the following Martin County Code violation: Section 105.1, Florida Building Code, permits when required, incorporated by Section 21.1, General Ordinances, Martin County Code for expired AC changeout. In the notice of violation, the respondent was given until January 11th, 2024 to correct the violation and was informed of the need to contact Martin County Code Enforcement upon doing so. On January 12th, 2024, I checked the permit status and the permit remained expired. Since compliance was not achieved, a notice of hearing was issued by certified mail on January 16th, 2024. Due to a missing address, I also issued an amended notice of violation to McDonald's Corporation on January 16th as well. They are marked as county's exhibits 4 and 5. Exhibit 4 is the amended notice of violation with the address added. Okay. Exhibit 5 is the notice of hearing.
All right.
The return receipt was not received, so on February 5th, 2024, I posted the property, as well as handed a copy to the manager on duty. A photo of the posting and the affidavit of posting are marked as county's exhibits 6 and 7. Exhibit 6 is my affidavit of posting. Exhibit 7 is a photo of my posting.
Okay.
I have spoken with the contractor of record by both phone and email, and I explained the violation and what needed to be done to correct it. I've also conveyed the same information to the McDonald's manager. Therefore, I checked the permit status again on February 20th of 2024 and saw that the cited violation had not been corrected. A screenshot of the permit status is marked as County's Exhibit 8.
Okay.
With that, I request that all the county's exhibits be received into evidence. Based upon the testimony and evidence, I request that the respondent, McDonald's Corporation, be ordered to comply with the cited provisions of the Martin County Code by March 29th, 2024, and if not in compliance by then, be required to pay a fine in the amount of $100 for every day the violation continues thereafter. The county has incurred a cost in the amount of $575 conducting this investigation and requests that the county be reimbursed this amount at the conclusion of today's hearing.
Okay, so what is it they have left to do?
They were past their 3 renewals,
Mm-hmm.
and they needed to contact the assistant building official and get him to pass their final inspection. We had some emailing back and forth. They did reach out, and he provided some direction to them, and then they never followed.
Okay, so it was an AC change-out?
Yes, sir.
All right. Okay. All right, and anybody here on behalf of McDonald's Corporation, looking out, seeing no one? Without objection, I'll accept into evidence the county's exhibits 1 through 8 in this case. Based upon that evidence and your testimony, I'll find that a violation as charged does exist on the property and order compliance on or before March 29th, 2024, failing which a fine in the amount of $100 per day will accrue. And I'll further award costs in the amount of $575 to be paid to the county at the conclusion of this hearing. Okay. Your next case is the Revocable Living Trust of Michael Prudhomme, 2019, with Michael Prudhomme, trustee. Case number ENF 2023-100427. And whenever you're ready.
Thank you, Your Honor. My name is Charles Amberzetti, and I've been sworn in. I'm a code compliance investigator for Martin County. The respondent, Revocable Living Trust of Michael Prudhomme, 2019. Prudhomme Michael, trustee, is not present. This case concerns the property at 3063 Southeast Grand Park Way, Stuart, Florida, 34997. This case was not generated from an anonymous complaint. According to the official records of the property appraiser of Martin County, the property owner is Revocable Living Trust of Michael Prudhomme, 2019 Prudhomme Michael Trustee. A copy of the property appraiser's record of ownership is County's Exhibit 1.
Okay.
On October 16th, 2023, an expired permit application letter was emailed to the Revocable Living Trust of Michael Prudhomme, 2019 Prudhomme Michael Trustee. A copy of the letter is marked as County's Exhibit 2.
All right.
Based upon the investigation, I issued a notice of violation to the Revocable Living Trust of Michael Prudhomme, 2019 Prudhomme Michael Trustee on October 31st, 2023, and is marked as County's Exhibit 3.
Okay.
In the notice, I cited the following Martin County Code violation. Section 105.1 Florida Building Code, permits when required, incorporated by Section 21.1 General Ordinances, Martin County Code for expired permit application for a new sign. In the notice of violation, the respondent was given until November 30th of 2023 to correct the violation and was informed of the need to contact Martin County Code Enforcement upon doing so. On November 28th, 2023, I checked the permit status and the application remained expired. On that day, I sent an email to the property owner, to which he replied. In his reply, he stated that the sign was in, and he also provided me with an attached photo of the completed work. A copy of the email and the attached photo are marked as County's Exhibits 4 and 5. In Exhibit 4, I sent him an email advising him that his permit application for the sign was expired and to fill out the form that I had attached to extend out the application. And if the work had not been started, he may cancel the permit application by following these directions.
Okay, and looking at Exhibit 5, it's just the European custom casework that's at issue, not the one above it?
Yes, Your Honor, it's the bottom.
Okay, so it basically is a change out of the sign insert, right?
Yes.
Got it.
In the email, he states that the sign is in, see attached. He paid and applied for a permit thinking with something this small, it was merely a formality, and asking if I could issue the permit, inspect it, and close it out. In my response, I let him know that I was not a building inspector. He was supposed to satisfy the conditions. I provided him with a screenshot of them, put on the permit application to turn it into an issued permit before the sign was erected.
Okay. Yep, I read that. Okay. You know, before you go on, what I don't understand is that, that obviously this is commercial property. He had to hire someone to do the work. He's talking to you, but we don't, at least not in the evidence, see who the sign maker actually was. Do we know who that was?
He did not have a contractor at this point in time. He hired a contractor subsequent to that exchange.
Okay.
His original application was for an owner builder.
Okay.
On December 19th, 2023, I checked the permit application status and the permit application remained expired. Since compliance was not achieved, a notice of hearing was issued by certified mail on December 19th, 2023, and marked as County's Exhibit 6. On January 9th, 2024, the property owner requested a 30-day extension, which he was granted, and an amended notice of hearing was issued by certified mail on January 11th, 2024, and is marked as County's Exhibit 7. The return receipt was not received, so on February 5th, 2024, I posted the property. A photo of the posting and the affidavit of posting are marked as County's Exhibits 8 and 9.
Okay.
Exhibit 8 is my affidavit. Exhibit 9 is a photo of my posting. On February 16, 2024, I offered Mr. Prudhomme the option of a stipulated agreement, to which he declined. I conducted a follow-up investigation on February 20th, 2024. At that time, I photographed the property's sign. The photograph accurately shows what I saw then and is marked as County's Exhibit 10. I checked the permit status again as well on February 20th, 2024, and I saw that the property owner had now hired a contractor who opened up a new permit application on February 12th of 2024, which has been denied in review. A screenshot of the original permit application status and the new permit application status is marked as County's Exhibit 11.
Okay.
I request that all the county's exhibits be received into evidence based upon the testimony and evidence. I request that the respondent, Revocable Living Trust of Michael Prudhomme, 2019, Prudhomme Michael trustee, be ordered to comply with the cited provisions of the Martin County Code by March 29, 2024, and if not in compliance by then, be required to pay a fine in the amount of $100 per every day the violation continues thereafter. The county has incurred a cost in the amount of $575 conducting this investigation and requests that the county be reimbursed this amount at the conclusion of today's hearing.
Okay, anybody here for the Revocable Living Trust of Michael Prudhomme, 2019? Seeing no one. Without objection, I'll accept into evidence the county's exhibits 1 through 11 in this case. Based upon that evidence and your testimony, I'll find that a violation as charged does exist on the property and order compliance owner before March 29th, 2024, failing which a fine in the amount of $100 per day will accrue. And I'll further award costs in the amount of $575 to be paid to the county at the conclusion of this hearing. Did Mr. Prudhomme say why he wasn't willing to enter into a stipulation?
I have the email with me, Your Honor.
I mean, gosh, if you offered to save me $275, I probably would agree.
Yes, sir. In the email, I said the hearing for the case is a few days away. I'm reaching out to offer you another option to the magistrate hearing. I've attached a proposed stipulated agreement where I'm authorized to give you 90 days to receive the permit. The cost would be $350 instead of the $575. You would need to come into the building department and sign and pay by Tuesday. Let me know if this is something you would like to do. His response was, Charles, I don't freely admit violation of code. I applied for permit, paid for permit, county didn't issue permit.
Okay. Okay. Some folks you can't help. All right. Next case is Capelli. All right, this is case number ENF 2023-070159, and the respondents are Richard and Ann Capelli. And Officer Counselor, you're going to testify. Again, you're sworn in.
Yes.
And whenever you're ready.
My name is Chris Counselor. I've been sworn in. I'm the Code Compliance Officer Investigator for Martin County. The respondents, Richard Capelli and Ann T. Capelli, are not present. This case concerns a property at 2929 Southeast Ellendale Street, located within Stewart, within Martin County, Florida. This case was not generated from an anonymous complaint. According to the official records of the property appraiser, the owners of the property are Richard Capelli and Ann T. Capelli. A copy of the property appraiser's record is County Exhibit 1. On July 24th, 2023, I inspected the property. At the time, I observed concrete poured over sidewalk without a permit. This complaint had been issued to us from the Public Works Department. At the time I photographed the property, the figures accurately show what I saw then, and it's marked as County Exhibits 2 through 8. Exhibit 2 is the property in question. You can see the distinct, there's a line between what was the existing sidewalk, and this property is a rental property. Mr. Capelli's tenants basically had poured a new layer of concrete over the sidewalk, creating their own quasi-driveway apron. Exhibit 3, this is just showing the address of the property. Exhibit 4. You can see the difference between this, where the sidewalk is and where the concrete was poured. Exhibit 5, that's, you can see the hard line between the existing sidewalk and where the new layer of concrete was poured over top of the sidewalk. That's Exhibit 5. Exhibit 6, showing the poured driveway in relation to the property. There's the line. Exhibit 7 and Exhibit 8, basically showing the concrete that was poured. Based upon the investigation, I issued a notice of violation to Richard Capelli and Ann T. Capelli on July 31st, 2023, marked as County Exhibit 9. In the notice violation, I cited the following Martin County Code violation, Section 105.1, permits when required as adopted by Section 21.1 General Ordinances of Martin County, and Section 67.201B, nuisance declared trash and debris, which has been corrected. In the notice of violation, a response was given until September 1st, 2023 to correct the violation, and was informed of the need to contact Martin County Code Enforcement upon doing so. I had spoken with the property owner, and he requested time because at the time in Golden Gate, new roads and water lines were being put in. So basically, he stated that he needed the time that once the new water lines would put in, he was going to take out the pre-existing septic tank and drain field, and then he was going to pull a proper driveway permit to do the work properly. The time was given, but compliance was not achieved, and a notice of hearing was issued by certified mail on February 2nd, 2024, and is marked as County Exhibit 10. For today's hearing, there's my signature with the violations. The return receipt was not received, so on February 9th, 2024, I posted the property. A photo of the post and the affidavit of posting are marked as County Exhibits 11 and 12. 11's a picture of my posting. Exhibit 12 is my affidavit of posting. I have spoken with the property owner and discussed the violations and what needed to be done to correct it. Therefore, I went to the property again on February 20th, 2024, and saw that the cited violations had not been corrected. Exhibit 13. Again, you can see the line between the existing sidewalk and the concrete that was poured. Exhibit 14. Exhibit 15. And Exhibit 16. Exhibit 17 is a permit history for the property showing that no driveway permit has been applied for and or issued. Exhibit 18 is a series of emails between our department, Public Works, discussing the property of Mr. Capelli's. Basically, what the summary of the emails is basically within the emails, Public Works had to go out because of the concrete laid, and they basically had to do some corrective action to basically free up, because since the concrete was poured over existing utility lines, Public Works did go out and basically make it accessible to the manhole cover. But at no point did Public Works indicate that because they did that, that they approved of the rest of the concrete being poured without a permit. So the emails are basically a discussion from Public Works to us and to Mr. Capelli, basically stating that, yes, they went out and Public Works did work to gain access to the utility lines, but a permit was still going to be required for the concrete work that was done as a driveway apron. I requested all county's exhibits be received into evidence. Based upon the testimony and evidence, I request that the respondent, Richard Capelli, and Ann T. Capelli be ordered to comply with the cited provisions of the Martin County Code by March 29, 2024. And if not in compliance by then, be required to pay a fine in the amount of $100 per day until the violation is corrected. The county has incurred the cost of $575 conducting this investigation and requests that the county be reimbursed this amount at the conclusion of today's hearing. And that concludes my testimony.
Okay. That apron, of course, is, a good bit of it is on public right-of-way.
Yes.
So,
Basically,
I mean, the county could go out there any day and just jackhammer it out if they wanted to, because it's on your right-of-way.
Correct. But since Campelli's tenants poured it, it's a makeshift driveway. So they're basically requiring him to get a permit, which would then have it done correctly, which, I mean, as it exists, it's not done properly. But they were hoping that he would follow the proper channels to get a proper permit, therefore fixing the
Okay,
issue.
but, I mean, I was looking at pickup trucks parked on the front lawn.
Yes.
Is there, I mean, the county's not going to permit that.
Basically, what would be required is it's not a driveway that's up to code, I would say, but basically it is a makeshift driveway, which is what the intent of why they poured the concrete.
I believe, if I understand your question correctly, when a permit application is put in, it would, being a apron driveway, it would envelop the entire thing, and the county would look at the whole thing, where the trucks are parked, where the driveway is going, the apron and all, and anything that's impermissible would be denied for. So if he got a permit, it would be for something that complied with parking setback. But the other right, with the whole thing, as it is now, it's just ad hoc concrete poured over the right of way.
Okay. All right, but you're not to the point of where you'd ask for an order to allow you to go and abate the,
No.
okay. All right. Gotcha. All right, anybody here on behalf of Richard or Ann Capelli? Seeing no one, I'm going to find that it is appropriate for me to accept into evidence the county's exhibits 1 through 18 in this case. Let me get the right case, 1 through 18. Based upon that evidence in your testimony, I'll find that violation as charged does exist on the property and order compliance on or before March 29th, 2024, failing which a fine in the amount of $100 per day shall accrue, and I'll further award costs in the amount of $575 to be paid to the county at the conclusion of this hearing. And just note for the record that although the docket says there's a violation of 67201B, that violation has been removed.
Correct.
All right.
Thank you.
Sure, thank you. Okay, let's see, the Gerson case. Okay, Gerson case is next. It's case number ENF 2023 100860, and the respondents are Eric or Gabriella Gerson. And Ms. Switzer, you've been sworn in.
Yes.
Whenever you're ready.
My name is Kelly Switzer, and I have been sworn in. I'm a code and compliance investigator from Martin County. The respondent, Eric Gearson and Gabriella Gearson, is not present. This case concerns the property at 3502 Southwest Cocoa Palm Drive in Palm City, Florida, 34990. This case was not generated from an anonymous complaint. According to the official records of the property appraiser of Martin County, the property owner is Eric Gearson and Gabriella Gearson. A copy of the property appraiser's record of ownership is County's Exhibit 1.
Okay.
On November 6, 2023, I received a case from John Colando, Code Compliance Administrator, during a sweep of the area. I inspected the property and found a tarp over top of the roof. At that time, I I photographed the property. The photograph accurately shows what I saw then and is marked as county's exhibits 2 and 3. This is a tarp over the top of the roof. It's just another angle. Based upon the investigation, I issued a notice of violation to Eric Gearson and Gabrielle Gearson on December 7th, 2023, and is marked as county's exhibit 4. In the notice, I cited the following Martin County Code violations: Section 105.1, Florida Building Permits when required, incorporated by Section 21.1, General Ordinances, Martin County Code. In the violation, the respondent was given until January 8, 2024 to correct the violation and was informed the need to contact Martin County Code Enforcement upon doing so. Compliance was not achieved, therefore I issued a notice. Notice of hearing was issued by certified mail on January 30th, 2024, and is marked as County's Exhibit 5. The return receipt was not received, therefore I posted the property, and at the Martin County Administrative Building, the posting and the affidavit of posting is marked as County's Exhibits 6 and 7. Posting? My affidavit. Exhibit 8 is an email correspondence from the property owner's attorney requesting a 1-year extension on the case. This was sent to our county attorney. The county's response is Exhibit 9.
Okay, hang on just a
Yep.
second, let me look. Okay, and Exhibit 8 is a copy of the notice of hearing. Was that
Yes, that was,
attached to
yes,
the letter?
yes.
Okay. Let me see Exhibit. Okay,
Okay. And Exhibit 9 is the county's response.
all right. I've read that.
I went to the property again on February 20th, 2024, and I noticed the tarp still on the roof and no permit has been pulled. At that time, I photographed the property and conducted a permit search for a roof permit. The photographs accurately show what I saw then and is marked as Exhibits 10 and 11. So that's the property with the tarp still on. And 11 is a permit search.
Okay.
Based upon the testimony and evidence, I request that the respondent, Eric Gearson and Gabriella Gearson, be ordered to comply with the cited provisions of the Martin County Code by March 29th, 2024, and if not in compliance by then, be required to pay a fine in the amount of $100 for every day the violation continues thereafter. The county has incurred a cost in the amount of $575 conducting this investigation and requests that the county be reimbursed this amount at the conclusion of today's hearing. This concludes my testimony.
Okay, thank you. Well, I guess we understand what the attorney was trying to accomplish, but in fact, if the Gersons fix their roof, it still just becomes then an element of their damages and,
I might point out that the attorney's letter has a case number for his lawsuit of 2022. So this damage has been in existence since at least 2022 sometime.
All right, so, all right. Anybody here on behalf of the Garrisons? Seeing no one, and the attorney's already indicated he's not attending. So based upon, I'm going to then accept into evidence the county's Exhibits 1 through 11 in this case. Based upon that evidence and your testimony, I'll find that a violation as charged does exist on the property and order compliance on or before March 29th, 2024, failing which a fine in the amount of $100 per day will accrue, and I'll further award costs in the amount of $575 to be paid to the county at the conclusion of this hearing.
Thank you.
Yes, ma'am, thank you. All right, Ms. Brown, oh?
We're going to the end of the document.
Okay, we're going to take you down here, the Peterson case. It's case number ENF 2023-120175, Samantha Peterson, Victoria Ripley, and whoever else, Jennifer Beth somebody, or let me just see who we got. Hard to decipher which names of first names and which ones are last names.
We had the same thing when we reviewed it.
All right, and Ms. Bush, if you raise your right hand, do you swear or affirm testimony about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, whenever you're ready.
My name is Tamika Bush, and I have been sworn in. I'm a co-compliance investigator for Martin County. The respondent, Samantha Victoria Peterson and Jennifer Beth Ripley, is not present. This case concerns the property at 8534 Southeast Date Street in Hobe Sound, Florida, 33455 in Martin County, Florida. This case was not generated from an anonymous complaint. According to the official records of the property appraiser of Martin County, the property owner is Samantha Victoria Peterson and Jennifer Beth Ripley.
Okay.
On December 7, 2023, I inspected the property. At that time, I observed the installation of a wooden fence with no permits. At that time, I photographed the property. The photograph accurately shows what I saw then and is marked as County's Exhibit 2. Based upon the investigation, I issued a notice of violation to Samantha Victoria Peterson and Jennifer Beth Ripley on December 21st, 2024, marked as County's Exhibit 3. And in the notice, I cited the following Martin County Code violations. Sections 105.1 FBC permits when required incorporated by Section 21.1 General Ordinances of Martin County Code. In a notice of violation, the respondent was given until January 10, 2024 to correct the violation and was informed of the need to contact Martin County Code Enforcement upon doing so. Compliance was not achieved, and the notice of hearing was issued by certified mail on January 24, 2024, and is marked as County's Exhibit 4. The return receipt was not received. The property was posted on February 5th, 2024, and the administrative building on February 9th, 2024, and it's marked as County's Exhibit 5. I have spoken with the respondents, both respondents, and at this time, they still have not complied with the violations. Therefore, I went to the property again on February 20th, not today, and saw that the cited violations had not been corrected. And this is a photo of the fence that still exists. Also a copy of the permit history.
Okay, those are 6 and 7. Okay.
Yes, sir. At this time, I do request that all the county's exhibits be received into evidence. Based upon the testimony and evidence, I request that the respondent, Samantha Victoria Peterson and Jennifer Beth Ripley be ordered to comply with the cited provisions of the Martin County Code by March 29th, 2024, and if not in compliance by then, be required to pay a fine in the amount of $100 per day for every day that the violation continues thereafter. The county has incurred a cost in the amount of $575 conducting this investigation and requests that the county be reimbursed this amount at the conclusion of today's hearing, sir.
All right, anybody here on behalf of Ms. Peterson or Ms. Ripley? Seeing no one, without objection, I'll accept into evidence the county's exhibits 1 through 7 in this case. Based upon that evidence and your testimony, I will find that a violation does exist on the property and order compliance on or before March 29th, 2024, failing which a fine in the amount of $100 per day will accrue, and I'll further award costs in the amount of $575 to be paid to the county at the conclusion of this hearing.
Thank you, Special Magistrate.
Thank you. All right, let's see, we've got a couple of fine reductions.
The 071 that's on your list up there has been removed right at the moment.
Oh, the Trinidad
Yes.
case, okay, so that's been removed. So now we've got BAF3 LLC,
Yes, sir.
and that's a fine reduction stipulation and agreed recommended order. It's case number ENF 2021-100063. Ms. Bradley, you've been sworn in whenever you're ready.
Okay. My name is Rachel Spradley, and I've been sworn in. I'm the nuisance abatement coordinator for Martin County. This case concerns the property located at 3299 Southeast Garden Street in Martin County, Florida. On January 19th, 2022, an order finding violation was issued by the Code Enforcement Magistrate to BAF3 LLC for Section 105.1 Florida Building Code permits when required, incorporated by Section 21.1 General Ordinances Martin County Code. Compliance was required by February 28th, 2022. On December 1st, 2023, an affidavit of compliance with accrued fines was issued reflecting an outstanding fine of the amount of $50,500 plus costs in the amount of $575. Staff has determined that a lien reduction is warranted. The current owners were not responsible for the violation and brought the property into compliance, and it offered to pay $10,000 to resolve the outstanding fines which have accrued. On February 25th, 2022, a special warranty deed was recorded changing the ownership from BAF3 LLC to BAF4 LLC. So it is technically the same people, they just changed the name of the company. They went from 3 to 4.
Okay, I'm looking at BAF Assets 4.
I'm sorry. Yes, sir.
Okay,
So that concludes my testimony for this one.
all right, the exhibits?
Exhibit 1 is the property appraiser showing the new ownership to BAF Assets 4 LLC. Exhibit 2 is the original recorded order showing Section 105 that they were in violation of, signed by Magistrate Werb. Exhibit 3 is the affidavit of compliance with accrued fines and costs that was recorded on the property. And then Exhibit 4 is their reduction request that they submitted.
Okay, and tell me again what the basis for the reduction is?
It's our standard practice.
Okay, no, well,
They submitted the amount, if that's what you're asking, why it's more than the standard 10%. They sent us the letter requesting to reduce it to the 10,000, so.
so it's basically the county accepting their,
Yeah, we're accepting their request.
and are you telling me that these are all the same folks? So it's
They just changed the
really,
name.
okay. All right. And so without objection, I'll accept into evidence the county's exhibits 1 through 4 in this case. And note that the stipulation recites what you have indicated and that it is executed by Kimberly Lewis, the area manager for BAF4 LLC. corporation. I wonder if she actually has authority.
She does. I have the paperwork.
Give power of attorney or, okay.
You want to see it?
Yeah, yes, please.
You look, I'll pull it out because I highlighted her name for you. The page that's turned is where her name is actually listed on there.
Okay. All right, I'm looking at a certificate of signing authority for BAF Assets 4 LLC, signed by Victoria Husband, Chief Compliance Officer. And for Management Authority, Kimberly Lewis, Area Manager, has been named. I'm going to go ahead and accept this into evidence as county's, the entire thing is county's Exhibit 5. Now 1 through 5. All right, and I'm going to find that it is appropriate to enter into the agreed order note for the record that Ms. Bradley has signed on behalf of Martin County. And this is, of course, a recommended order that goes to the County Commission for approval. All right. And next case is the Mayo case. It's ENF 2022-040288-01. Respondents are Michael and Mary Mayo. And this is also a fine reduction stipulation.
Yes, sir. My name is Rachel Spradley, and I've been sworn in. This case concerns the property located at 8082 Southeast Hidden Bridge Court, Jupiter, in Martin County, Florida. On June 15, 2022, an order finding violation was issued by the Code Enforcement Magistrate to Mary Riggs Mayo and Michael Mayo for Section 105.1 permits required when incorporated by Section 21.1 General Ordinances, Martin County Code. Compliance was required by September 30th, 2022. On February 1st, 2024, an affidavit of compliance with accrued fines was issued, reflecting an outstanding fine in the amount of $48,300. The admin fee of $575 has been paid in full. Staff has determined that a lien reduction is warranted. The respondents were responsible for the violation. However, they brought the property into compliance and have offered to pay $4,830 to resolve the outstanding fines which have accrued. And that
Okay, and your exhibits?
yeah. Exhibit 1 is the property appraiser, showing that Mary and Michael Riggs are the owners. Exhibit 2 is the original order placed on the property. Exhibit 3 is the affidavit of compliance with accrued fines. And Exhibit 4 is the request from Mrs. Mayo for the fine reduction.
Well, that's short and sweet.
Mm-hmm.
Reduce my fine. All right, so you look at the stipulation, appears to be in order. Without objection, I'll accept into evidence that county's exhibits 1 through 4 in this case. And note for the record that the stipulation recites the testimony has been signed by Mary Riggs Mayo on behalf of herself and her husband, and Ms. Bradley on behalf of the county. And we'll go ahead and approve the agreed recommended order in the amount of $400,830 to be paid to the county. Okay. And anything else to come before us?
That's all, sir.
All right, good. All right, well, thank you all very much. We'll see some of you, I guess, on the, whenever that was, the
March 13th.
yeah, on the 13th. Okay. And then the next regular hearing is
20th.
March
20th.
20th here in Chambers. Okay, thank you very much. We stand adjourned.
Thank you.